Good evening, ladies and gentlemen. Welcome to the Wareham Planning Board regular meeting of Monday, February 9th, 2026. The time is 6 p.m. We are in the Multi-Service Center, room 520 at 48 Marion Road, Wareham, Mass. We are also available via Zoom, and we are being televised live on Wareham Media. I'll start with a roll call. To my left.
Big Baptiste here.
Julie Moran here.
Carl Schultz here.
Sam Corbett here.
And Jane Gleason here. Full board here. We do not have Josh Faraday yet. I'm expecting him this evening, so we can start with preliminary business. Approval of the minutes from January 12, 2026. I did find one typo that I think the set that came out to us today did not have it corrected on the 370. There's a place where it says 3170 instead of 370.
Oh, got
Right
it.
at the very beginning of that item in the title of the item. So we'll change that, but with that Scrivener's error, is everybody okay with that set of meeting notes?
I move that we accept the minutes of, was 12th, right?
January 12th,
January
correct.
12th as amended.
Second.
All in favor?
Mike Baptiste, aye.
Julie Moran, aye.
Carl Schultz, aye.
Sam Corbett, aye.
And Jane Gleason, aye, so 500. First item, or this next item on the agenda is the zoning rewrite presentation by Judy Barrett. That was a holdover from our meeting that was, the entire agenda was pushed to this meeting when we had a snowstorm. So I do we have anybody here from the Barrett Planning Group?
John?
Nobody's raised their hand at this time.
Okay. So I have a
I
feeling.
move that we continue that agenda item.
Okay. Unfortunately, we're going to have to continue it indefinitely because there's no one here to help us with a date.
Well, it's not a public hearing.
Yeah, right.
Yes,
But
let's-
we usually try and do a date
I
specific.
move that we continue this to a date indefinite and authorize the chair to negotiate such a date.
Very good.
Second.
All in favor?
Mike Baptiste, aye.
Julie Moran, aye.
Carl Schultz, aye.
Sam Corbett, aye.
And Jane Gleason, aye. Next item 3 is project 15-25 or plan 25-15, 80 Makepeace Company, A&R off Maple Springs Road. Do we have anybody here from 80 Makepeace?
For clarification, is this the same item number as before?
No, this is item 3. It's the one above it. Do we have anybody online, John?
There are people there, but no one has raised their hand at this time.
I wonder if there was confusion, given that this was on our agenda for our last meeting.
Yeah, the 26th.
I mean, seriously, that high-paid attorneys can't figure it out.
Why don't we,
Make a motion, we do not endorse the A&R.
Or do we hold
I
it?
second the motion.
yeah. I guess I would prefer that we wait till Josh comes. He might have received a telephone call. or
There's a
something.
motion and a second.
We started talking before you seconded, so
Yeah,
I'm going
sorry.
to stand by that.
I just would like to wait till Josh appears.
Okay.
Yeah.
So we've
You
had
may have-
discussion, now I'm going to second the motion.
I know.
Well,
Wait, we can vote.
we've got to
Wait,
vote on it.
wait, Madam Chair, I'm sorry. As you know, this has been a very, I'll relax. So we don't want to, do we think Josh is going to come?
Yes.
Josh is expected at the meeting.
Yeah, any moment. When I talked to him at 4:30, he said he'd be a few minutes late, but he'll be here.
I withdraw my second.
Also,
So
For now.
we will table that for the moment until Josh gets here and move on to item 4, Bayside Agricultural Inc., A&R at 0 Maple Springs Road.
What was the number on that?
There is no number, as far as I know.
Good evening, members of the board. Attorney David Hennig, on behalf of the applicant, Bayside Agricultural, Inc. I'm from the law firm of Galvin & Galvin PC at 10 Enterprise Street in Duxbury. Good evening, everyone.
Could you restate and spell your name for our Scrivener?
Yes, first name is David, last name is Hennig, H-E-N as in Nancy, I-G.
And as your professional representing the project, I'm going to have you raise your right hand and swear to tell the truth, the whole truth, and nothing but the truth.
I do.
Thank you. So I'm going to give you the floor.
Yes, so this is an application for an A&R for, I believe it's 3 parcels of land. It's my understanding that there is going to be no change of use on this land, that the land is really unbuildable, so that it can't meet the definition of what a lot is under the subdivision law, which is why the applicant believes that this A&R should be approved. And as far as the frontage, we believe that there is enough frontage on the parcels as well. So, we're here for an application for an A&R, and really just, we're here to answer any questions that the board has at this time.
Could you describe where the frontage is coming from?
Just have-
I guess I'm not seeing any roads near the property, and that's where I'm curious about where the frontage is coming from.
On either public or private way.
Yeah,
Yes, required under,
An adequate way,
yes, right.
yeah.
Yep.
an accepted adequate way.
That's vital, giving vital access.
So this,
I just have-
from my looking at it, it's really, it's,
Stuck in the middle of
yeah, yeah.
It's A,
If I could just have one moment. The applicant himself isn't here, but he did give me his number to contact him if there were any questions that the board had for him.
Okay.
Just give me one brief moment.
So to give you a little bit of background, the project that just before this one that we've tabled for the moment, just because there's nobody here to speak to it, we're having a similar issue with, that from the best read that we, the board, can find in the zoning bylaws, there are 2 criteria for something to be an A&R. There's frontage and there's access. And we find nothing that differentiates between lots and parcels in the bylaw nor in state statute, and that's where we're struggling with this. And I believe that you've got a similar situation here with frontage and access not being, at least being not defined.
Sure.
So that we can understand where those 2 things, which we understand to be the town's required criteria to be.
And I believe, Madam Chair, again, researching my little heart out, the statutory definition of subdivision in Massachusetts General Law 4181L does not exempt non-buildable parcels from the requirement, as I read it. And lacking definitive legal opinion to that point, I have to rely on my interpretation.
right. And,
And under MGL 4181L, every lot shown on a plan must have adequate access. Now, do the lots that these parcels are part of all have adequate access? I didn't think so when I looked at it.
So the information that I just received, so I misspoke. There is no, it looks like the frontage requirement does not get met under this. However, there is access through the other parcels that are adjacent to this new lot, is what I'm told.
But, okay, but that doesn't apply to my strict understanding of the law. And that's not even our bylaws.
and we use the same criteria for every single A and R for the last, as long as I've been here, 6 years.
Having no other,
And just to continue, because you made reference to the preceding one, the non-buildable, I can speak, designation is a note on a plan. It is not a deed restriction. It is not a covenant or a conservation easement. Therefore, it is not an enforceable land use. So just
and-
putting a note on a plan means nothing in terms of restrictions.
yeah, and the state statute has a definition of lots, and it refers to to basically be buildable, with a building on it, or a building to be on
To be
it.
built, yeah, be able to be built.
But there does not seem to be any counter to that of an area of land, a defined area of land that has no buildings on it. There doesn't, I mean, it seems that there's a common usage in the profession of civil engineering of parcel versus lot. But I have not been able to find anything that confirms that in state statute, and that's part of our trouble.
The other thing is, I pulled the two plans relative to the David Fletcher lots, assuming that that would become part, or at least abut it with an easement. And it appears that there is an old cart path, that it was 1966 taking, but again, it's limited access. 20 feet wide, it indicates, but it really, if you look at the plan, it's very hard to determine, in fact, whether it connects to this, to get out to Charge Pond, because ultimately it ends at Charge Pond Road. But you really, it's hard to determine whether that even connects to this from the plan.
And whether
was
it's
an
a,
A&R plan,
whether
by
it's
the way.
a deeded easement,
Just-
that's
Yeah.
firm, that's not just sort of, oh yeah, drive across my
Yeah, right.
property.
There is an easement. So the primary lot is landlocked except for an easement over the other lands of the applicant. Let me see if I have anything on that easement on here.
Yeah, and the purpose of the A&R law is not to create landlocked lots.
Right,
And this would be creating a landlocked
yeah.
parcel.
But even
of
with the
land,
easement,
part of land.
what I would have expected is to have lots, assessor lots 1004 and 1005 on the plan to at least show if in fact this path goes even to Charge Pond.
Right. Right.
And then would have to make an analysis of, does it provide vital access and all of that. But honestly, from the A&R plan that was submitted, I really couldn't trace whether or not this actually connected with the Fletcher property to lead out to Charge Pond Road, so, which is the public way.
Yeah, it's, what I'm told from the applicant is that there is access through that easement. It goes through both Charge Pond and Maple Strings Road, the easement, so.
Yeah. Which we'd have to see, and would have to,
So what are the characteristics of that easement? Is it a road that's capable of sustaining a
fire
40,000-pound fire truck?
Yes, it is. It's based on what the applicant.
Well, but there's no evidence in.
Yeah, it would have to-
in the-
fire department.
If the board, if I may, if the board is requesting additional information, we can always provide it. We could continue this for one meeting. If the board requests additional information, get whatever information may be needed, so we can shore up if you want extra information on that easement. Whatever the board needs, just let me know and I can.
Yeah,
happy to get it.
that may make sense.
I'd like to see the easement. I'd also like a fleshing out of the plans that are referenced. It is Plan Book 61, page 840, Plan Book 60, page 872, to really try to identify on the ground what that looks like, besides even the frontage issue, so,
And then we need certification that that easement is a valid easement.
yeah, that's right. So,
And
a little bit of a laundry list, if you will.
so, and one more question, so you're hearing, you said this is a non-buildable lot. How is that established as a non-buildable lot?
Well, I know that the plan definitely states that it's it's not a buildable lot.
But that's a note on the plan. Is that recorded as a covenant in land court? And if we record it as a covenant in land court, that would be fine with me then.
I don't believe it's recorded as a covenant in land court, no.
Then it becomes non-enforceable and is a meaningless note on a plan.
If I could just have, I guess in simplest terms, just a list of what the board would need for the next meeting. I think that'd be helpful.
I
Well,
think it's identification.
the application doesn't meet the requirements, so,
Right.
but if you want to continue to, how many days do we have? When was the date on this application? We have 21 days.
Yeah.
So 14 days would be to the next meeting. That,
Yeah, it's dated 12/16.
12/16?
Yeah.
We're already past the 21 days.
Well, we're first hearing it now.
What,
Well, yeah. First time on the agenda.
And if I could just ask also what was missing on the application, just if just any changes or any corrections need to be made?
well, there's no frontage, the easement, certification of the quality and easement. Because the easement is not an accepted way by the town, we need certification that it meets, what, I think 16-foot wide, surface, capable of sustaining.
Fire.
If it's any help, I drove by it today on the way here. It's none of those things.
So
Yeah.
that's really what we're looking for.
Right.
And as I said, in those two plans, to really identify what it is we're even talking about as far as road is concerned. Because it really was difficult to determine if it really was a continuous road of any kind. Although there was a 1966 town layout for limited access, 20-foot wide, but is that really what's there?
1966 was 60 years ago?
60 years
Yeah.
ago.
So that's the point. Was it ever done? What's there now? So,
I believe the parcel is, to the extent that it matters, it's a wooded plot of land, so as to, how we know it's not buildable, it's just completely wooded, from what my understanding is of the parcel.
You can cut the trees down and, again, my concern is that a note on a plan is not an enforceable restriction.
The road is currently accessed from what I'm told, it's an access road that accesses cranberry bogs, it's used by cranberry farmers, and it looks like it's also used by power companies at the time, so whatever trucks those individuals drive, the road can support that, but I will get any other information that the board does require.
and really, it's what is problematic when at some point it's 20, but then it narrows, so it really has to be of
And
an
the problem
adequate
is
width.
it's not an accepted adequate way.
Yes.
Therefore, there's no requirement to maintain it. Okay, these are all questions that we have.
And just-
Right.
Just as,
I think it doesn't meet the requirements.
just
Why
as,
should we continue it?
and just as a note, the fire department also does, it's believed that the fire department has accepted this road and has approved it in previous plans for current use that it is now with the solar farm. It's my understanding that the fire department has accepted that road.
Which solar
So which solar farm?
project is it?
The parcels that are already there have numerous solar farms on them. So I guess when that was all put in place, the road was already discussed and determined.
We know them all.
This could have been one of the Makepeace projects.
Yeah.
Is this one of the Makepeace projects, Mike?
It's Surecran.
Sure, oh, sure, this is the Surecran, okay.
Yeah.
Then I know which project it is.
They have two solar arrays, Surecran, and there's one beyond that. I'm not sure who it is. I think it's
Surecran is
ABM.
one of them, yes. Surecran, yes.
Then there's also a fire department.
Amerisco is the other one.
I make a motion, we deny the A&R. rather than just sit here. Let's do something.
Second.
I think I can request a rewording of your application, is that we find that this is a subdivision of land, not an approval not required, that the application represents a subdivision of land, which I think is the alternative, as opposed to, you don't actually deny an A and R, I believe. We find that it is a
Don't deny and
subdivision.
you can't condition.
Right. Yeah, so we find that it's a subdivision of land, which says it's not an A and R. That's what I think the motion should be worded as.
So moved.
And you still second it, Mike?
Still second it, yeah.
You want to have discussion, Madam Chair?
If we're not willing, if we don't feel that it has frontage, then,
It's not an A and R.
yeah.
Any way you look at it, it's not an A and R. Doesn't meet any requirement, in my opinion.
From what we've got in the bylaw and what we see
Right.
in the statute.
And what we've done for at least 6 years that I've been here. Never approved anything like this.
Yeah, I would just, again, reiterate that the regulation, I believe, Section I, General E, a lot shall mean an area of land in one ownership with definite boundaries used or available for use as the site of one or more buildings. So again, because this land is unbuildable, we would submit to the board that it does not fall under the subdivision law, and therefore an A and R should be approved.
So we got some gray area, but it doesn't meet our A and R
But again,
requirements.
how do you say it's not buildable?
Just, I believe through the nature of the land, that it's a fully wooded lot.
The woodedness doesn't have anything to do with whether it's buildable or not.
I think he's saying that the note on the drawings is,
Yeah,
But
Again,
that-
and,
but
and we have heard that argument before, but because I did the research which says a note on the plan is not a binding,
right.
I believe also because there's no frontage on it, I think that's what makes it not buildable. You can't build on it because it doesn't meet the frontage
because
requirements.
if it doesn't have
is
frontage
landlocked.
requirement, then we can't do an A
We've
and R.
got, so we've got a catch-22 here, which we can't, we get our hands tied.
agreed. Agreed.
So you done?
Well, we haven't taken a vote, we've
I know that.
discussed. Do you feel strongly, I'm weighing my vote based on how strongly you feel you want to continue this.
Oh, we're gonna set a precedent, it's gonna come back and bite us in the butt.
Well, it already set a precedent and it has caused a great deal of confusion among the members of the board because we continued the previous one 3 times.
Yeah.
We have not gotten clear direction, excuse me, I shouldn't say we. I have not gotten clear direction on my questions, so I'm still asking the same questions.
Same. I keep saying the same thing over and over, that we've got black and white words that tell us what is required for something to be an A and R, and this doesn't meet it. However, I don't believe that this is a subdivision either, if subdivisions are about, I don't believe it's a subdivision,
Wait, subdivisions are not just about building homes.
but they talk about lots. There's no talk about parcels, and that's where I struggle.
Except that, then my struggle is that this parcel is part of a lot. The subdivision applies to the entire lot. If you want to do something with this little piece of land within your lot, you tackle the whole lot.
And I don't see in front of me, even if you were going to look at the A and R, the access, where it is, it doesn't show on this plan, where
Right.
there's access.
So if you, again,
Doesn't mean they
I'm
can't
going to
reapply
defer to your
with
wishes. If you think that we've given him enough questions and you want them to come back, or we could deny it without prejudice and let him file
I think denying it without
Yeah,
prejudice is probably the
or
best.
find that it's a subdivision without or, I'm concerned that it's already past the date.
Yeah, I am too. I am
So,
too.
Madam
I-
Madam Chair,
but-
through you to Josh, have we already missed the date to rule on this?
I don't think so.
What the concern is, the plan says what date?
12/16.
We didn't get it back then.
Well, that's what
Just
it's,
recently got it. I'll have to check when it was stamped in. but-
That's actually the date that's on that they wrote on the top of the application form. So it's not a stamped date.
No, we didn't get it back then.
Oh,
This has
okay.
not been sitting in our office for.
okay, so then we're not at risk for that problem.
Right.
So I think I'm more inclined to go the deny without prejudice, so that if.
Wait, how about a different way to say the same thing? Request that they withdraw without prejudice and come back with answers to these questions.
That's a possibility too. I mean, if, they've had one pass before the board, and sometimes there's a rabbit to be pulled out of a hat. And I don't want
What
to
changes to be
deny
made?
you the opportunity to do that. Show
So-
us the rabbit, you know?
So, Josh, if I wanted to support allowing them to withdraw without prejudice, could we waive the filing fee so that they don't have whatever it is, 25 or
refile.
100? I'm asking,
Yeah,
You've done it past.
we have done it in the past, but I don't, if the idea is to allow them to come back, why not just make the motion to continue?
because
Mostly because of the 21 days.
the 21
Well,
days,
if the applicant agrees to the continuance, then they waive the 21-day standard.
Yeah, true.
Okay.
Yeah, that's true.
Just for the record, just so I can note any objection, the law states that an A&R does not confer any zoning rights. This lot does not need frontage because it's not, or this parcel doesn't need frontage because it's not a lot and it's not a buildable parcel. And
where are you reading from?
Yeah, it's a statute.
Which statute?
I believe it's 61A, I believe. Just check. Hold on, no, it's the. It's going to be found in MGL chapters 41, sections 81K through 81GG, which is the subdivision control law.
Wait, slow down, because I'm trying to write
GG.
this down.
81 GG through.
81K through 81GG. I don't have the specific section in there, but that is what the subdivision control law is. And it's not a buildable parcel.
Is the word parcel used in that language? Because I couldn't find the word parcel in MGL anywhere.
I think that the differentiation comes down to what a lot is and whether or not the land is buildable. So it focuses on that. Like there could be a parcel of land, but it doesn't become a lot unless it's buildable. Is what I would submit.
Except that we're taxing this as a lot, and it shows as a lot on our map, and it's a lot in the registry.
I think in some instances, it seems that lot and parcel are being used interchangeably,
Constantly.
and lot is defined, parcel is not. The general consensus among civil engineers and surveyors is that lot and parcel are two different things, that one is buildable, one is not. So there's like this whole,
But again, how do we establish non-buildability? If it's not recorded in the registry, and there's no deed restriction, covenant, or some other thing, there's no way to record non-buildability.
so, let me put
But you're
this out
recording the
there.
plan,
Let me
obviously.
put this out there. For it to become buildable, presumably you're gonna build something there, and you have to go and get a building permit to do that. And to get a building permit, you have to prove that you have frontage and access, the same issues. And if you don't have them, then you can't get a building permit. So does that,
And if it becomes built, if you want to build on it, you'd have to go
Except-
through
well,
subdivision control.
Except, again,
That's the crux of our argument. I'm sorry.
Yeah.
you've already raised the previous issue, and their note specifically says it's not buildable except for solar. So they're planning to not use the lot frontage issue, and they're planning to build something on it.
but doesn't solar require a building permit?
Yes,
But
but
We're digressing here.
But I'm
I'm
saying-
sorry, I know.
We do have a motion and a second on the floor as well.
I know,
And we're
I
still
know.
doing discussion on
Yeah.
that. We have not.
So the plan that was submitted that states that it's not buildable is going to be recorded. So that will be recorded, that says that it's not buildable. And we don't believe that the building commissioner would ever issue a building permit unless the lot complied with zoning. And because it doesn't comply with zoning, specifically the frontage issue, it's never going to be able to comply with that frontage requirement. So it's never going to be considered buildable because the building commissioner can't issue a permit. So that's really the crux of our argument.
Except if the zoning changes.
Although it's going to be combined with what presumably are buildable lots, these two, correct? Right. Let's make it bigger, so.
This is just the subdivision of land. I mean, why don't... Okay. We have a motion in a second.
Refresh my memory of what the motion is.
That we find that this is a subdivision of land, not I think that's the way we're supposed to word a not acceptance of an A&R. An A&R says this is an approval not required because it doesn't represent a subdivision of land. We're saying, I think the motion says because it doesn't have adequate frontage it doesn't have frontage on an adequate way, we can't find, it doesn't meet the requirement
Of an A&R.
of an A&R, therefore, that the only other thing is it's a subdivision of land. I think those are the only two choices.
Before we step in something that we don't want to step in, I'm going to ask Paul if he has anything that he wants to add. This is Paul Mattos.
Paul
He's
doesn't really want to.
from Allen and Major. He's our engineering
With
consultant.
Allen and Major Associates. Again, as previously stated before, if you're designating it as a parcel, you're noting it on the plan that it's not to be considered a buildable lot, the planning board should be endorsing these A&R plans. There's court cases on file, and it's inside the A&R handbook that you can show deficiency in zonings, and the planning board should be endorsing these plans.
So quick question to you. So if it says that it's not buildable on a plan, so there's a
It's
note on a
recorded.
drawing, what is binding about that?
It's just making people aware that the lot is not to be considered buildable. And anybody that's going to be purchasing that property would be looking at this lotting plan that's recorded at the registry, and those notes would be identified saying that it's not buildable. So if someone decides to buy it, then
But
they're either
A&R
buying
plan-
it.
Excuse me, just a question. A&R plans are not filed at the registry.
All A&R plans are filed at the registry.
I didn't think so. Okay,
Yeah,
that's
they're
okay, that's,
You're
thank you.
recorded.
That's
There's a
why-
distinction that might have been
Must be
missed.
recorded or they're not effective.
So,
But you don't give notice to anyone.
And the reason why the A&R plan needs to be endorsed by the planning board is for it to be recorded at the registry of deeds. If it doesn't have the planning board signature, then it's kind of saying that you can't file this plan unless you're showing an 81X, which is a plan showing no new lines and ways on the plan.
so that
That's
might
the
be,
reason why,
that might be some new information,
Yeah. but it's-
Carl,
sorry, I knew
that adds a little bit more robustness to a note on a drawing, that it does get
If it's
registered.
recorded.
It is recorded.
Sorry, I knew that. Sorry, should have made that.
Does
clear.
that change your,
Well, it.
Perspective on this?
What addresses my concern that a note on a plan,
Could or could not.
Could, would.
and then it's up to future building inspector to notice the note on the plan.
Check to see if it's recorded or not. If not, it means nothing.
Yeah, it's not effective unless it's
Right.
recorded.
Okay,
In land court, there's a timeline for when they have to record.
yeah, that's a shift from what we've been talking about.
So that is recorded, it's established. So, which is, this case I distinguish from the case where the folks didn't appear, the last one.
Mm.
Because that has exceptions, in my opinion, but
Does
we'll
that
go into that after.
change your, okay.
So, your motion stands to say that, to deny it as an A&R and say that it's a subdivision.
Correct. Because that's what it is. not an A&R.
Can you elaborate?
It doesn't meet any requirements we held people responsible for at least 6 years I've been here.
The
You held
frontage
this-
and the
exactly.
access.
We held every single person, we held them to the same standard. This doesn't meet it, therefore it's not an A&R.
Yeah, it's 1541.
I mean,
Says frontage.
period.
Says frontage and
Right.
access.
I mean, we have to go by what we have to go by.
Can I see the neighbor's letter again?
Yes. Yeah, there it is. Keep in mind, this is not this project.
No, but he, um, so, Madam Chair, back through you to Paul. I'm reading a letter that you wrote on a similar application.
Yep.
And I don't see the reference to the law that supports what you're saying, which
We
is
make-
which is why I asked the question to
Yeah.
start with.
No, we make reference to the letter that was submitted by the attorney for the client at that time. And there, he references all the cases that are in the A&R handbook, which denote that the planning board, if it went to court, the court would remand it back to the planning board, that the planning board should be endorsing these plans. And he cited 3 or 4 cases that are in the A&R handbook.
But my opinion is that Attorney Bowen, when he attended, said these don't apply.
Well, at least one of them,
At least one of them did
Yeah.
not apply.
right.
I don't understand the question. To me, it's black and white.
Okay, so we have a motion, we have a second, we've had discussion. What would you like to do, Madam Chair?
Well, I guess we need to vote on the motion. One more time. Reiterate the motion.
I do not believe this is A&R, I believe this is site plan
A subdivision.
Subdivision.
of a subdivision, yeah. It does not meet our requirements for A&R. In no fashion at all, that we've always enforced for the last 6 years that I've been here that I'm aware of. If something happened before that, I'm not aware of it, but every single one.
So are you putting any caveats on your denial? Like like without prejudice or?
Without prejudice.
So they'll be able to reapply?
Yep.
And
If they choose an A&R, I'll vote against it again.
second stance?
If the board won't consider a continuance of this matter?
It's a motion on the floor.
So
We have to vote on that
Yeah.
before anything
I
else.
think we need to vote on it
Yeah. Again, without prejudice.
without prejudice, so a reapplication would,
Yes,
the concern being the 21 days.
with responding to the
Well, the
questions that we
21
raised.
days,
Yeah,
Yeah, we're okay on that.
but that was the original
yeah,
Yeah.
no.
reasoning for this,
Right.
and the motion's been on the floor.
We don't have an answer on that, really. Could or couldn't.
Could or
No.
couldn't,
Be within or without. We don't know that.
okay.
Within or without what?
21 days.
Oh,
Yeah,
but
right.
we could, if we did a continuation, we could get the applicant to state that they would waive that
Right.
requirement.
Yeah.
If we were to do the continuation.
Which we're not right now.
Right, we have to act on this motion in a second.
Okay, well, I think we need to vote.
Like Baptiste, aye.
So an aye vote means that we find that it's a subdivision of land.
With the caveat that they, without prejudice,
Right.
which is, given that, I vote aye.
Carl?
I'm going to abstain. I'm so totally confused by lack of clear,
Sam Corbett, aye.
And Jane Gleason, aye, particularly because of the without prejudice. It gives you the opportunity to come back before us with this project.
Understood. The board had mentioned the idea of potentially waiving a fee.
Yes.
Would the board consider that as well?
Yes.
As long as Josh is okay with
Yeah, we have.
You get a, I don't know if there needs to be a motion or no approval or anything like that on that, but just with the understanding that the fee is going to be waived for the reapplication.
Yes,
That's our understanding.
yeah.
it. So we could clarify that without prejudice implies that we intend to allow them to waive the application fee for this.
That's part of it. They're two separate things,
Right.
being without prejudice and
For this
no fee.
same application.
for the same application, correct?
Did we vote on that and just make it clear?
Okay.
Sure.
I move that we waive any subsequent fees should this applicant choose to refile this A&R with additional clarifying information without substantially changing the plan.
Second.
All in favor?
Mike Baptiste, aye.
Julie Moran, aye.
Carl?
Aye. Oh, I'm only voting on the waiving the fee.
Yeah.
Sam Corbett, aye.
And Jane Gleason, aye.
So, just a clarification, Madam Chair. In the future, we have not taken an official vote on waiving the fees. Should that be part of our policy?
I think a case-by-case
I think
basis is
on a
my
case-
opinion.
Yeah, I think on a case-by-case basis
Okay.
is perfectly fine.
Okay.
So,
Thank you.
Thank you.
thank you.
Wasn't that fun?
Sorry for, this is something we've been working on.
No, it's-
Not just your project, but there seem to be
I just-
some,
No offense, I mean,
yeah,
No, it's nothing to do.
gray areas and
You
holes.
walked right
and-
into a,
There's no offense taken. It's part of my job.
Yeah, you did walk into a hornet's nest.
Yes.
just, I know that we've moved on. You're an attorney, correct?
Yes.
If, when you come back and you want to defend this, if you could bring legal citations.
Sure.
And provide those in advance,
Sure.
because that's,
We'll send it to
we're trying
town
to,
council.
understand. Particularly, I'm going to go back and read 81K through GG, but I can't find anywhere where it talks about parcels, and everybody comes in and talks about parcels. All it talks about is lots.
Yeah, and we've been struggling with that, and it's terminology between lots and parcels that seems to be very definitive to some professions and not so definitive in the statute, nor in our zoning bylaws. So it's this, like, mess that we're trying to navigate.
Understood. Thank you all.
Thank you.
Appreciate your
Thank you.
time. Thank you.
Thank you.
Moving right along. Josh, we started to talk about 1525, the 80 Makepeace. And there's nobody here from 80 Makepeace, and I'm wondering if they maybe were unaware that we had moved it from the agenda during the snowstorm.
From our last one to this one.
Yeah.
Madam Chair,
Yes?
I do have an Eric Chrysler.
Yep.
No,
Nope. Nope.
Okay.
Sorry.
not this application. Thank you, John.
It's 370.
Right, that's 370. Thank you. Getting my peeps mixed up. So is it possible that they just were not aware?
Yeah, I'm checking my email now. Yeah, it's a strong possibility that they weren't aware.
I'm just guessing.
so you're
that-
hiring attorneys out of Boston that bill by the thousands of dollars an hour. You don't think they check the agenda?
I'm not.
So, all right, so
But-
what do you want to do, Madam Chair? We can't continue it without them.
Right. And I hate to be a pain in the butt, but we need to follow our rules sometimes.
Can I also ask a question?
Well, we got to be, yeah.
Eleanor Majors had indicated the plan doesn't meet all our requirements anyway. Did we ever get anything further from them? We never
And-
saw that, we didn't see, it was continued also to see the 25-foot easement, which we never, I don't think, Josh, we ever got a copy of that prior to our January 26th meeting?
Wait a minute, are we looking at the same project?
Yep.
Yeah,
No, this is the
Spring Road.
Oh, yeah, okay.
1525, and Allen and Majors noted several deficiencies in the
Yeah.
application.
Okay.
Which was, this date later was dated January 7th. So Paul, do you know, did you all receive anything?
No, we have not.
Okay. So we have that, Josh, and then we had requested, one of the reasons for the continuance in December 22nd, I guess it was to ask for that easement, which again,
Oh, yeah, the easement, right. I thought you
So-
said
Which they
setback.
would have provided by the last meeting.
right. That's why I'm asking,
Right. I
in
mean, that's-
advance of
we
the
were-
meeting, they didn't respond to, and Paul, just to clarify, so you didn't receive any response to their letter, whether they objected to it or otherwise?
No, we have not.
Okay, so,
Really wasn't much to object to our letter. We're just kind of stating the facts on what our opinion is as it relates to parcels and lots.
right.
So,
But then you said that estimate does not provide all 18 items.
yeah, I think it was missing the zoning, the locus map or something at a 1 inch equals 2,000 scale. I think that's the only thing that was really deficient from the plan.
Right,
So it could be
Well,
something
plus the
that-
25-foot certification about the
right.
The easement.
the easement.
So if a meeting wasn't postponed because of the storm, we would have had to receive all that to go
That's my
further
que-
on
That's
what.
my question.
Right.
Right.
So they didn't provide it, and they're not here. And we're just such good people, we're gonna kick it around for a while.
And the options, other than kicking it around for a while?
I'll
Well,
make my same motion.
so, they
Deny
didn't
without
provide us
prejudice.
with what we had requested.
Right.
Both our engineer and ourselves. At the same time, we canceled, and I assume they were notified that we had canceled. So they could have provided it.
Well,
They
they
did use
either
a-
knew that it was canceled, or they showed up and found out that it was canceled.
I can't believe they wouldn't have checked.
And, yeah, where did they
I
think
mean,
it went?
it wasn't canceled, it was postponed to another, they had to use certain language when they did it.
Meeting canceled due to weather.
That was posted, wasn't it?
Yeah, I mean, that was posted on the town website, that was posted on the front door.
Right. So,
So do we want to take this? have
So
the
I
same
make a motion, we deny the A and R for 1525 plan.
Well,
Without prejudice?
in this case, we could say we're denying it because the application is incomplete,
Right.
yes,
as opposed to not finding it's a subdivision.
right, exactly.
So does this need to be without prejudice for them to reapply?
No, I
If
would,
it's
Why?
incomplete?
They're not
I would
here.
say no, because it's incomplete versus,
Okay, all right.
yeah.
Is there a second?
Second,
All in favor?
Got a second, right?
Yep.
Mike Baptiste, aye.
Julie Moran, aye.
Carl Schultz, aye.
Sam Corbett, aye.
And Jane Gleason, aye. So,
Thank you all.
Madam Chair, I'd like to make a formal request that we need to put on the agenda a formal and it's open, it's an open meeting, education session on the points that Paul and Phil are trying to raise, because I don't understand them. And Attorney Bowen's comment, and Josh, I gave you all of my questions, and you said Phil was gonna call me, and he didn't.
Oh, I
No, I'm just saying. So,
know that.
so I would like to have a presentation that says, you guys are struggling. Here's our input, professional input, legal, professional engineering input. Here's what you're missing. Here's what you're struggling with. And it needs to explain to me lots, parcels, which sections of law, why it doesn't have to have frontage on an adequate way.
Who'd
So
that be?
the other piece of that is, to the extent that it's possible, I would like it if Judy Barrett or her colleague Bob were able to
I-
join us for that, because I think that we might have some shortcomings in our zoning bylaw,
Right, zoning bylaw.
that this is the time to address them while we're doing rework of the,
Right. And this needs, it's not a public hearing, but it needs to be done in an open meeting.
yeah, maybe we do an off-cycle meeting at some point, and I don't know whether it's possible to get Judy and Bob involved.
Yeah.
But I think that would be useful.
I don't have, my request was broader than that. You could ask the Almighty to come and give us discernment.
I think I'm more likely to meet with success if I ask Judy and
But
Bob.
I'm accepting whoever you think is a good person to help us work through these
Josh.
issues.
So the Citizen Planner Training Collaborative,
I took the course. I'm adamant that I understand what that course said.
so you don't think me reaching out to them and bringing in one of their trainers would be beneficial?
You could do that, and they address this. It's a very small section of one of their,
And that might be useful for the rest of us
and I'm
who haven't
okay
done what
with
Carl
with
did.
that as an alternative. My request
I think that would be
was,
helpful.
it could be anyone who could speak in a caring, compassionate way, understanding the depth of our struggle. And if you read, I think, the intro to the A&R handbook, it says this is one of the most fraught areas of zoning law for such a simple concept. I think the introduction actually says that.
And I would submit that a straight, non-buildable lot is one thing, but when you have this Maple Spring, which is not a strict non-buildable, with the caveat that it has, that's, makes it even more fraught with challenges.
Right.
But there
Particularly while,
was some notation on the plan for the,
With the exception of supporting solar
that.
or
clearly,
agricultural.
clearly we're
Could be a
not,
battery storage.
we're
Yeah,
not
so
supposed to
it's-
consider use for an A&R, but they've already signaled
They put something out there
they
that really
were
just
denied a solar project, so they're
muddied the
attempting,
water a lot.
Well,
they're
what is-
attempting to,
We don't want, they're not here.
No, and so
But
that's
just
not fair,
discussion,
but
what
that
does
was,
supporting,
I-
if you're non-buildable, with the exception of supporting, whatever that means, it's not a legal term as an attorney that I'm aware of. So there is so many gray areas that,
so then the next thing is if they submit an A&R, but they write a whole lot of caveats on the plan,
right,
does that mean I have to accept, because they say it's an A&R, I have to accept whatever they decide to write on the plan?
No, again, I think if you look at the.
That's, no, you don't have to answer it now.
Yeah.
These
It's a
are the
rhetorical
things, these are
question.
what I'm struggling with.
I'm just referring back to the A&R handbook, and if you look at Chicarone versus Planning Board for Drake, they say a landowner submitted a plan showing a division of land into 3 parcels. 2 parcels shown on the plan contain a statement that the parcel was not a building lot. The 3rd parcel contained no such statement and also did not meet the frontage requirements as specified in the zoning bylaw. The court found that, in effect, the landowner submitted a single lot plan which did not constitute a subdivision under the subdivision control law, and concluded that the plan was entitled to A&R endorsements because it did not show a division of land into 2 or more lots. Again, they're using the word lots for buildings.
Except this A&R says they are going to build something on
But
Well,
that doesn't
that-
mean
and
they-
that plan
They're saying
had-
building, they're not saying they can't build on it. It's the same thing like for all these agricultural properties. They could go ahead and put a building on there that's not going to come before the planning board, even though they don't meet required frontage because they're agriculturally exempt. So they could put any size
But
building
this
that they
isn't,
want.
they're not agriculture exempt.
for solar.
If they put a large-scale battery project on there the fire truck can't get to, how do I deal with
But
that?
we don't know if they're doing that.
They actually said they carved that exception out.
That's,
Is that battery?
They said
it's
solar,
supporting
and
solar.
under Mass General Law, solar
48
encompasses
tree.
battery.
yeah. So, and that's really why it's fraught, this whole process, which is non-buildable, we understand non-buildable. It's when there's carve-outs, and you show that to the building department, they're like, oh, okay, off you go. And we don't have access, and it's, you get a battery storage on it, and you have a fire, and, you know, it just, it's a challenge.
What I talked about last
just
time
not-
is, the particular lot they're talking about, and Michael knows all about this, there's one area that's set aside, it's gravelled, the road coming in is passable, but on the other side of the bog, there's a little pipe under a little cart path that's not accessible. The fire truck would fall through. It's a little galvanized pipe about this big with some dirt over it, where they pick the berries, or they unload the berries. It's a great place, and they know it, and that's where they go every year. But across the way is not passable, so if there's a fire up there, fire truck's not gonna get to it.
Yeah.
I mean, I've walked this area, and I've walked all ADM property for the last 45 years. That's the way they all are. They have one area where they park the truck, they
Right,
load
they
it.
come in and they don't go very far into the
No,
bog.
they have one area where they put
It's
down
not like they
gravel.
drive all the way around.
It's
So,
easily
I-
passable, but the other end
I
is
want to
not.
wrap up this
Yeah.
discussion.
Yeah,
We're
no,
talking
agreed.
about an
Yeah.
application.
Sorry.
Let's move on.
But what I'm
Application
taking,
is on the agenda.
that you've already voted to find not a subdivision. You already took action on
We
it.
did, yep.
Just, I'm hearing that there's an opportunity that the board would like some training, or that's what I'm gonna take this as. Would you be amenable to hosting something off-cycle or
Sure.
prior to a meeting?
Yeah.
Okay,
I think we have to.
Yeah, we need some help on this.
okay.
And,
Then I'll-
and I fully respect Alan and Majors and Rich, but we're not getting,
So let me bring in another opinion.
well, no, I'm
Or
okay.
a training.
Whoever.
Yeah,
I got an idea, I'll move forward with it,
Yeah.
I'll let you know.
okay.
Excellent.
Moving right along. The next item, continued public hearings. Project 16-25 or Plan 25-16, 370 County Road LLC site plan, or special permit site plan review, 370 County Road. And I believe we have Mr. Chrysler online. Thank you. Do we have anybody else from that project who would wish to speak?
I have one hand raised for Danny Patrick.
Okay.
Madam Chair, point of order.
Go ahead.
Before we begin discussion on this project, I would like to get clarification on, is this a new application or is this a continued application? And what are the conditions of that? If it is a continuation, what are the conditions? Because I don't believe we have a full board that can vote.
That's, yeah.
Yeah, I would say that this has been remanded back to the planning board
And,
from the previous application.
okay, and that would then mean that we bring forward all the documents, but it's a continuation, it's not a new application.
Well, I think there's a little bit of gray area there. I think you could consider it a new application in some regard, as you did post a public hearing for it. The abutters were notified.
So let me rephrase
Yep.
the question. Under the law, if I miss 2 meetings, am I eligible to vote? One of those meetings was on the previous application and one is on this application.
The Mullen Rule would cover you for one missed meeting.
Because that's why I said for the extended
Yep.
project. So I'm not eligible to vote,
Nor am I.
Ms. Moran.
not
So we
available
only
to
have 3 eligible members, and because this is a special permit, it cannot pass.
Well, or you have a constructive approval.
No, that, I'm not advocating that. We-
I'm just working through
In
what are the.
in the
yeah.
past, where we got a special permit that did not have the full 4 members out of the 5, it was a denial. We didn't say it quite right, but it was a denial. So I'm concerned about
So
that,
does the
which is
board
not
remain a
what,
five-member board when two are ineligible? Or does it become a three-member board?
It remains a 5-member board.
Board.
Any supermajority.
Even if you had 3 members assigned to the board, your votes would still be based off a 5-member board.
so that
That's a
is a
problem.
procedural problematic issue, which
That is
is
a
not
problem.
what the applicant intended,
Right,
nor is what the remand intended,
No.
Right?
so,
and nor is it in my heart what I
No
feel,
one,
but
no one missed a meeting on purpose to put us in this
no,
position.
no, it
think
was
we can
before I
say
was
that.
on the board.
Right, right.
That's my problem.
Yeah.
Right.
and I would have perhaps acted differently on the 8th if I had understood what that meant.
So, the only other option is withdrawal, and they resubmit.
Well, or we let Josh, I mean, because you negotiated the settlement, not you personally.
Right.
But, and their attorney, and
Maybe talk to Attorney Bowen about what,
So, well, I'll offer up this piece of information. The planning board is rehearing this application as a remand instead of other applications that have been, I'll say, mediated behind closed doors,
Yeah, I know.
right?
Yeah.
Going through the mediation process. So instead of going through the mediation process, the planning board felt it more appropriate that it get remanded with the new information back into public hearings. Under mediation, there is an option to reach a settlement for a majority of the board, not the required supermajority for the special permit. So let's say let's say this application never came back before you as the board tonight and stayed in mediation, you guys could agree to a joint settlement, which would have been a majority of the board, not a supermajority.
settled it without a remand.
Right. Which would be a majority vote of the planning board. So, the reason that it's here before you tonight, well, and previous nights, is because that was agreed upon. It might have been the mediation, or it might have been between both attorneys. But let's say the planning board came to a decision tonight, came to a decision. Let's maybe next meeting, whatever. Let's say you came to a decision, then the planning board could always send it back to the two attorneys and say, we want to handle this as
Settlement.
a
as
settlement of the complaint.
Shall we, through the chair, shall we speak with Attorney Bowen, who has been involved in this case and was involved with the remand, to recognize the situation and determine how we can,
How best to move forward?
yeah, how we can
Yeah.
complete the hearing
And
and
I mean, historically,
complete the deliberation on the project.
sure. And historically, what you guys have done is when you've noticed that there's been a failure of the board to obtain a reasonable vote, you've allowed the applicant to withdraw, reapply without prejudice,
Right.
and that resets the voting.
Yes.
I'm a little hesitant to give up that offer tonight, just because of where we are with the complaint
Right,
and the remand and
Right.
all that, so I don't think that's appropriate. What I would suggest is, if it is possible to get to that point, and that's the move that we decide to make, or it's the majority under the, the remand, that scenario, I think what we should do is move forward with the hearing tonight as if you did have the ability to take action, just so everyone can understand where we're at. Remember, with the remand, there was an expected decision deadline. We did get an extension of that, but until I believe it's.
First meeting in March.
Yep.
Yeah.
So we definitely have some time between now and your next meeting to kind of iron out some of these procedural details.
so
But I think it would be appropriate for the applicant to understand where the board is coming from and,
Sure.
kind of where you're at.
Yeah.
So if I'm ineligible, I can't deliberate?
No, you can. You can deliberate. You would be no different than an associate sitting on the board.
Yeah, right,
The only thing that gets removed from your ability is the ability to cast a vote.
correct. Right.
So you're not dropping out for
Okay.
conflict
I
or
wish I
something.
had known this, I would have
Well, I think,
done extraordinary.
that's going forward, is if you have this situation, we look at who can vote, and it has to be a different way of handling the remand.
Yeah, I'm hoping
Court-
this is a
the
unique
court, I'm sure,
situation
will
and we don't
allow
get
that.
stuck in
Yeah, let's make
Yeah.
this a unique situation.
two-year-long applications.
I know,
Yeah.
I know.
Maybe it's
Yeah.
been that long, Eric might know.
It has been, we
Yeah.
started in
Applicant has been patient.
been long. Longer than that.
2023, we started.
So,
2023, yes.
so I guess in conclusion, what I would suggest is the planning board move forward as if you had the eligibility to vote this evening. At least give the applicant an idea on where we're at. You did have a final peer review from Allen and Majors. I think it would be appropriate to kind of let them know. And if it comes down to the procedural aspects of getting a vote determined, we got at least 2 weeks before your next meeting, and we got, a couple more after that before the deadline.
No, I thought you said the beginning of March. Or did you say?
First meeting in March.
First meeting.
Which
in
meeting?
March.
Oh, first
We
meeting.
could,
So,
One more meeting
we
before.
we could put
Yeah.
this on the 22nd.
Yeah.
Okay.
22nd.
All right, I'm just trying to make sure I understand the.
yep.
Okay. Do you need me to-
It's there.
Okay.
So, looking back at my notes, what I've got as items that were outstanding, I brought up a question about the swept path, that there were a couple places where the front bumper of the truck was hitting the fence. And looking at the latest drawings, it looks like that's cleared up, so I'm okay with that. The next item I had was the 50-foot versus 75-foot setbacks, and apparently there's a zoning freeze in place, so they are the 50-foot setback. The next item is maintenance plan and irrigation plan. And Josh and I talked about both of those and thought that perhaps the maintenance plan could be part of the conditions.
Excuse me, point of order, why is there a zoning freeze in place? I do not believe they're perfected their zoning freeze in October, and I submitted that concern. Jillian did not file the paperwork on time,
Julian did not file, what
perfecting
would it, a definitive subdivision?
Yes.
So I know that there was a preliminary,
Right,
and it
and
was
they-
very
which-
specifically geared toward what appeared to be a zoning freeze.
Right, but they, then, 2 years from that date, you have to file a definitive in order to perfect that. Otherwise, the zoning protection expires. That's a question. We don't have to resolve that tonight. That was a
Okay.
question that I raised. There is no definitive subdivision, as far as I know, filed for this property, and therefore the preliminary expired.
So it sounds like we've got to resolve that or confirm. that.
Clarify that. That was,
Yeah.
I raised that question.
Yeah, and I think the only question I would have geared towards that is, what did the COVID tolling do to preliminary?
Oh, that
subdivision?
was, that, you're right, we did have that discussion.
Right,
But
Yeah,
I
COVID.
never heard an answer
okay.
to that.
So, because remember the acts of 2024 were very broad in the
Yep.
description of what was extended under that time
But
frame.
Just have
I'm
to
not
look at
sure
that.
that didn't expire before the,
Okay, so we've got to confirm that.
all of that was just
One way
a
or the other.
question
Yeah,
to
yeah.
clarify the.
No, it's a
Sure.
fair question,
Yeah.
but
Okay,
Well, because, and it's, for the applicant, that's important as well, so that's cleared up, so, for sure.
so,
is there, and forgive me for not being able to memorize the plans, is there an area on the plan that encroaches on the 50 versus 75?
Yes.
There is. Okay.
Yeah,
Okay.
I think so.
I just didn't, I wanted to
Yeah,
make
that-
sure we weren't going down some rabbit hole that had
Yeah, no, I
effect
think it's the
on.
back.
It's important because the plan relies on the 50-foot setback.
Okay, okay.
Yeah,
That's what I just wanted to know. Thank
Yeah,
you.
At the backside it does.
Okay.
So then, maintenance plan, and we talked about the possibility of that being a condition. An irrigation plan, we talked about that, Josh and I did, about, that's somewhat optional, that it's not a requirement. But what is a requirement is, that the landscaping,
Survive.
survive. And so maybe what we can do is, so they could put in irrigation or not. It's a crapshoot on their part. But I think that we could put a condition in about confirming that the plants are thriving with an arborist doing a yearly inspection.
Okay, and yes, we could certainly do that. The problem
that
is
as a-
we
as a
have no
condition.
mechanism to ensure that happens, to review it, to check it. There just isn't staff to run an audit.
Well, that may be,
But it
You
doesn't mean
can
you
require
can't,
them to,
doesn't mean you can't require it.
yeah.
The issue is, do we have the ability to monitor it? But we have an undertaking to do it, which would be, I think, important.
If we drive
Yeah.
by there and see there's a
Yeah.
problem, we
It's
could
basically an
exercise the
undertaking.
right.
So, that would be my thought, rather than,
Or,
So we're gonna start
concerned citizens could regularly drive by, hint, hint. He's got his head down,
He's
he's not
got his head
listening.
down, yes.
I don't think this one is
Neither.
visible from the road anyway, so.
And then decommissioning plan and the process bond.
conditions.
Conditions.
And then we need to make a statement because the right-of-way, or the easement runs right through the,
Right. Actually, we looked at the latest drawings, and yes, the easement runs right through the property, but there is an alternate route that goes around the property.
that is the easement.
That
Well,
will be
it
the
could
access
be.
road.
Right.
Well, then, but that's a legal proceeding.
That is a legal
Right.
proceeding, but they have provided something. I was going to insist that we put something in the conditions
Right.
that recognizes that there's, and I think maybe we still should.
We
It's
did,
a modification
Right.
to the easement.
Right, exactly. But I think that it's not in our purview to rule on it.
Right. Agreed.
But I think that
well,
we could,
we could condition to say it needs to be resolved in the appropriate court. And
correct. But just so you know, there is a road that's shown on the drawings that goes outside the fence and connects to the road here and goes around and connects to it here.
I did see that, but that isn't the easement.
Correct. But that's where,
And the Fletchers would need to be willing to accept that.
right,
Fieldings.
right, but that's a.
Fieldings, not
Fieldings,
Fieldings.
right, but that's a land court issue, so.
Yes.
But we can make reference to it in our conditions. So those are the items that I had on my list. I don't know if anybody else has further.
And for me, I was tracking the Allen and Majors review, and based on their January 6th letter, it does look like that the issues that they had raised have been resolved.
They have been, so.
Yes, yeah. Because there were a few that I was on my list
Yeah,
that have been resolved with the revised plans. So,
I mean, isn't the third, it's Eric Chrysler,
hi,
and last name spelled Crisler.
yes, thank you.
The third point in the Allen and Majors peer review, is that what we were just arguing, that third point about the setback? Is that, because I think the engineer brought up an order of conditions. I don't know if that satisfies what
sorry.
the
No,
setback issue.
The order of conditions is the Conservation Commission approval.
This is the original letter. I don't have
Okay.
the one
The
that.
latest,
was
yeah,
set up.
okay.
So Conservation Commission works under the Wetlands Protection Act and their local bylaw. What the planning board is talking about with the setback issue is under our 2019 zoning bylaw, where the setback requirement from the property line was 50 feet. That's now been enhanced to 75. That was the discussion of the setback.
I don't know if Eric Lintala is in the room, but we did get to move the array to the south, which I think helps with the design.
He is in the room, and I'm sure he appreciates your reduction in the project.
So, sounds like we need to continue to our next meeting.
Public hearing.
Yeah, it's, yeah, all right. Is there anybody here who wishes to speak on the project?
Is there anybody else, John?
No one at this time.
Close the public hearing.
We could do that.
What was that?
Close the public hearing.
Uh,
Are we looking for any more information or data or reports?
We're just looking for confirmation about that zoning
50
freeze.
versus 75, right?
Does that prompt us to keep the,
I think
Public
we
hearing
should-
open?
I think we should keep the public hearing.
Yeah, I
open.
wouldn't
Okay.
close it.
okay,
Yeah, okay.
all right. So continue it
sense.
to our next meeting,
Yeah. And have the answers to all of that, right?
yes?
I move that we
Just, well,
continue,
Let's check with the applicant. Mr. Chrysler, are you okay with continuing to our next meeting on February 23rd?
I am.
Thank you.
Thank you.
I move that we can continue 370 County Road to the meeting of February 23rd.
Second?
All in favor?
Make Deputy stay.
Julie Marie and I.
Carl Schultz, aye.
Sam Corbett, aye.
And Jane Gleason, aye. 500. Okay, thank you, Mr. Chrysler.
Thank you, guys. Have a great evening.
You as
too.
well. Next item, 3-25, Plan 25-4, Rick Valenti, 1031 Pierceville Road, definitive subdivision.
I believe we have someone online. No, sorry, no. Will, I thought I saw,
You're in person.
I knew I saw Will. Sorry about that.
Good evening, William Connolly, Connelly, with Zenith Consulting Engineers. So I believe since the last meeting, we received conservation approval. An order of conditions was issued. We also submitted the HOA documents as requested by the board. And I think those were the only outstanding items, so if there's any additional questions, I'd be happy to answer them.
So my list included the sidewalks, which I see you, those look great. And so two-sided up until the last house on the right, and then one-sided for the rest of the way. The HOA paperwork, which I've seen, the street trees were on my list. And I honestly did not check whether they are mentioned in the HOA and maintenance of those trees, because the street trees end up on private property once
Right.
the lots are sold.
I know we discussed that with the attorney prior to the HOA
Yeah,
being written. I have not read it though, so I'm not sure if he included anything about the
yeah.
trees.
Did not.
And Jane, the only question I had, and I may have been answered last time, did we get the street light at the end of the road?
That was the last item on my list, was the street light at the end of, at the intersection. And I see that there's a pole that's close to the intersection that's on this property, not on town property, that has a light. At least there's a note for that.
Yes.
Is this a new plan? I missed it if it was on the last plan.
This was revised in November.
Oh, okay, so it was there. I just missed it, thank you.
Yeah, so it's right on the lower side,
Good point.
so
Yeah.
on the left. as
I
you're
think that's
coming.
really important for people coming out in the dark back there.
Yeah.
Understood.
Well, and my guess is there a light there anyway? Because Paper Mill Road comes in and typically an intersection like that would be lit.
No.
It's
There's
not.
none?
It's dark. I've driven back there.
Okay.
I got lost back there in the dark.
Come on, Kyle. You're from the country.
Yeah, I don't know that I've got anything further. Does anybody on the board have anything further?
Just a few things that, in the Allen and Majors letter, a number of areas were addressed, but I know that they had some recommendations for conditions. So I guess I would want to make sure that.
Make sure that those get
Basically,
in.
that,
Yeah.
that those conditions that we feel are applicable would be included.
Yeah.
I also, I'm a planning board member. I am also a retired real estate attorney. I'm not here to comment on the enforceability or legality of the HOA document. But, however, so council did draft this?
Yes.
It's your understanding? So, having spent some of my career doing condominium documents, there are, and it could be that I could speak to council and we could work through these. I just want to make sure that our future owners who buy this property have an HOA in place that is clear, concise, provides for reserves, provides for a budget, an annual budget, where you establish for that year what the amount per, whether you do it by month or quarter or annual, and I don't see that that's there. There's some challenges with the definitions. We have common facilities that talk about various things. We have the stormwater management system that has an operations and program associated with it, but it's defined differently throughout the document. Sometimes it's capitalized, sometimes it isn't. Common charges talk about common areas not defined. And I just want to make sure that when this is transitions into the new homeowners, that they are able to execute on this document. There is a discussion about fees and costs. There's nothing about reasonable attorneys' fees and costs. So some of that, I think, and again, I'm here as a planning board member, not counsel to the planning board. That is not our role here. But again, for us, I think it's important that for the new homeowners, that they understand what the developer's responsibilities are, what a new homeowner's responsibilities are, and that they can execute on this document. So if I could, I would ask the board's permission to send these comments to council, because right now, I don't feel comfortable approving or voting on this in the current condition that it is in. So,
I move that we authorize member Julie Moran to send her comments to the applicant,
Council.
whoever the applicant.
yeah,
Second.
whoever that might be.
Yeah, I'm sure they'd be happy to
Okay.
make
so
whatever.
Maybe you can get to Josh who council is, because I don't think we've ever met council on this point.
Well, I think what we'll do is we'll send the comments to Will, and he can forward them off to their
Okay.
council.
Yeah, absolutely.
Okay.
Make sure it's on the deed.
Yeah, this needs to be recorded at the
Right.
registry, so, yes.
All in favor?
Mike Baptiste, aye.
Carl?
Julie Marie and I.
Carl Schultz, aye.
Sam Corbett, aye.
And Jane Gleason votes aye. Any further comments from the board before I open it to the public? Anybody in the audience who would like to speak?
Have you seen the latest?
My name is John Christofolsky. Last name is Krystoffolski. I'm in a land abutter. So I just got several questions here that still haven't been answered, and a confusion whether it's here or at the Conservation Board. What is the final outcome on the sidewalks?
Oh, I'll let you, go ahead.
So the sidewalk runs around the left-hand side of the entire roadway until the last house there. at the end of the cul-de-sac. And then on the right side, it goes until the second lot.
So on the bottom left-hand side, that's my brother's property there, and there's been an issue, I know, with the elevation was higher, and supposedly they straightened it out. But at the meeting, it was also brought up that there's still going to be a problem there with two sidewalks, that the land is going to have the water come into my brother's property. I'm right to the left of my brother. That's not been resolved then.
You might ask.
No, they have a requirement under their stormwater maintenance program that says no water can escape the property. So if they're building a sidewalk, it would likely be sloped into the street, which would then be captured in their stormwater and infiltrated into the basin.
Yeah, and all the drainage was reviewed.
Well, that was a problem, because you also stated that the abutter, it would bring water to the abutter's property, and you asked Will to go back
Can't do
and
that.
figure something out. So I just want to make sure that that's been resolved.
Yeah,
So-
go ahead, Will.
There is no runoff from the proposed roadway here.
Okay.
We have to make sure that when we do these drainage designs, that there's a reduction in both volume and rate of the stormwater runoff, which we've done. That's been peer reviewed by Allen and Major, and I believe they've sent in a letter that the design is adequate.
All right, and then I know the last time you also mentioned that the water pitch was gonna come out of the development onto PS4 Road. I brought it up at the conservation, but they told me to bring it up here, that the runoff on top of PS4 Road, it's a very steep hill that goes down a county road. About a year and a half ago, the town repaved from County Road to the top of PS4 Road. And I told them I keep having washout at the bottom of my property, and it goes down. I can't keep seed there, so they put a Cape Cod berm there. I request a Cape Cod berm be all the way down to the base drainage down there, because the property at the end of PS4 Road is our property, and I have pictures. When I left the last meeting, I took pictures. It's constantly flooded down there. So if that can be addressed, definitely.
That would be within the layout. That's not really,
Well, like you say, you've directed the water away from that property. These pictures that I took, like I said, you can see it, and the water that comes off that on a regular rainstorm, and the sand that just comes out of there. Now you're gonna add more water to down there.
we ended up proposing catch basins to capture all the water from the roadway at the beginning of the intersection there, so there will be,
At the top of Pierceville Road? Or at the bottom of Pierceville Road?
the
No,
entrance to
they're not doing any work on Pierceville Road.
Right, so those catch basins are where, at the entrance?
the entrance of the proposed subdivision.
Who would I see about?
You're at the end of County Road?
No.
Or you're at the end of Pierceville at County?
That's a separate property. I'm at 53 Pierceville Road.
Okay.
My brother's at 55 Pierceville Road. He's the one with the sidewalk issues with the drainage there. On the corner of County Road in Pierceville is lot 1037A. It's an estate to the Christopolskis at this time.
Okay. That's 738
County Road.
738 County. Okay. You're the next one up.
Yeah,
And then is your brother,
he's 55, right next to the development with the road and sidewalk is.
okay, so is he 49 Pierceville? Okay.
Yes.
All right, got it.
Say sorry.
No, I'm just trying to keep track here. Okay.
But no, I would just like a curb to be ran down here so that it doesn't become a lake down on that property.
Where is this photo?
This photo's 53 Pierceville Road
Yeah.
here. The development's up here.
They can't
Yeah,
construct
I
on
think-
Pierceville.
Right. I think what I'm getting.
I'm just asking, there's a problem now, and then with this water being dumped out of that development,
Yeah, it wouldn't. It couldn't be the requirement of this application to
No.
continue the work down Pierceville Road
no, I'm just saying.
because these are right in front of your house.
No.
This is county up here.
This is in front of my house here.
County.
This is the two drainage systems now. That's looking up Pierceville Road.
This is up Pierceville.
Correct.
This is down Pearsall to county. Okay? And this is the Cape Cod berm you want extended
Yeah, so that,
down to county.
no, down to the catch basins that's down there to alleviate the constant washout in the little sized puddle that comes down there. It's more than a puddle. You can take a walk out there and you'll see it.
If I'm assuming this is your lawnmower.
Correct.
If I'm sitting on your lawnmower, the entrance to the proposed subdivision is behind me.
Correct.
Okay, and that's what I'm getting
Yeah.
at. So if I'm looking to the right off your lawnmower, is this your brother's property or your property?
Neither. 738. It's in the
So it's
state.
even further down.
It's at the corner of Peaceful and County Road.
Yeah, and what I'm saying is it could not be the requirement of this application for him to do work on Pierce Hill Road.
No, I'm asking if he can, if the town can put that berm down to the basin to alleviate that. With the more water coming out of that development now.
We can have the conversation with municipal maintenance.
nope, that's
but
fine.
Yeah, this isn't the time nor place to discuss that.
Okay, well, when I brought it up to conservation, you said bring it here, so that's why I brought it here.
I must have misunderstood what your goal was.
All right, thank you on that. And then the tree management. What are the trees? Back in November 5th, he was gonna walk out there and label the road, mark the road, and what trees are staying, not staying. That was November 5th.
That was for the Conservation Commission. They just wanted to see the limit of work, which we provided those, staking those out in the field.
So again, the trees right next to the sidewalk and all that, the existing large pines, they're gonna be left or removed?
They're gonna be pretty much removing the trees right up to that property line, abutting the property to the left-hand side.
And then the other thing is with the HOA, we keep hearing on the HOA, it has to be approved, or like you said yourself, they want to spell it out. Because the snow removal on the street, you have the maintenance of the road, upkeep and stuff.
Right.
Like I said, these people, and they were gonna go to the registry of deeds. They inquired about it on the 22nd, and they were told to go to the registry of deeds to discuss it, and you wanted it in writing of everything that it's gonna consider for a cost. I'd just like to know if the HOA has been, or a draft has been established yet for that.
That was the draft
Yeah,
that we were.
that's the one that I have some issues with.
Right, so my only concern on that is that that's gonna be very expensive, as well as the bond. Right now, the conservation's requested a large bond of money also to cover 20 years, so these people are gonna be going into that development. What's not to say if that development changes, do those rules still affect that land for the next 20 years versus they're gonna have HOAs on top of, their mortgage as well as everything else?
All of that goes to the land, not to the owners.
Right.
Right, so
So
that will
it's
never
on-
change for that
It's
20-year
on the
period.
deed, it's
Correct.
a deed restriction on each deed.
Yeah. And it will, in what, I want clarification of what it covers. And then every year, so what I think, on behalf of owners, we don't want to see that everyone gets a big bill at the end of the year and is not aware that there has been snow plowing and maintenance of the wastewater and maintenance plan, that is, sorry. I just want to make sure that there is a process, and in Massachusetts, for HOAs generally, there is a process by which a budget's established, people are aware, because each owner would be a member of the board, so each owner is aware, can vote on it, and I just don't think right now this document is such that the planning board would feel comfortable approving it on,
Right, because I know you all
for new
mentioned that you want
homeowners.
to you want to have that HOA specify everything, whether it's snow plowing, road maintenance.
Exactly.
Everything, before you take a final vote.
Correct.
Is there a way that I can see, just look at the draft, or is that public?
Yeah, I think it's
Is it in the
posted
file?
on the website, on the town website.
Yeah, we might have uploaded
It's a
it.
public document, so the
Yeah.
answer is yes.
Okay, no, I just want to make sure before the vote that,
Sure.
everything is spelled out there,
Yeah, yeah,
followed through.
right. And that's what I want to work on with council, to make sure we're all clear. And you asked about one of the areas that I think is important is the operation maintenance plan for the stormwater management system. And that will be part of this document, and obviously, there will be, eventually, there'll be a general cost associated with it, but we want to make sure that it's included in there, so everyone's clear of what's involved.
Right, that was taken care of,
Yeah.
the conservation.
Yeah,
They
that's
came
what
up with
the-
the price on
So,
it.
That's
so
what the
you guys
bond
are
is
aware the
about.
Conservation Commission and their approval required a performance bond of 270,000 to cover 20 years worth of stormwater maintenance and upkeep.
Okay. I'll get it, so it must be in the, I'll look at the order of conditions, that would have it.
There was
Okay.
2 conditions, right, so
Yeah.
if those
Okay.
aren't met, then it will not pass here?
Yeah,
All
that
of
would
it.
have
But
to
they've
be,
got to pass.
is it being posted at,
Construction.
Yeah, it was the Conservation
requirement.
Commission wanted it prior to construction that it be posted.
okay,
All we need is that the order of conditions was
Right.
issued. We don't,
Yeah.
we don't get into the nitty-gritty of what they say.
Yeah, I just brought that up because it is your purview too as well to condition stormwater maintenance. So I wanted you to be aware that it's kind of already been handled, but
okay,
you should at least make reference to the order of conditions
yes,
in your findings.
Yeah.
That would be appropriate.
great,
Thank you.
thank
I'm all
you.
set.
Thank you.
Thank you, Will.
So we'll be back next meeting.
What does the agenda look like?
We've got Water Whiz, we've got the 53G accounts, and we've got 370 County Road.
Then that's fine. Yeah.
So is the reason for the continuance the,
Yes.
Sure.
Sorry. Sorry, Will, I interrupted.
no worries.
My name's Melissa Almeida, last name spelled A-L, M like Michael, E-I, D like dog, A. And I live at 39 Pierceville Road. So when a bunch of trees were dropped to build 41 Pierceville Road, the following winter, when the wind started whipping because of the winter storms and all of that in March, the winds, as you know, come across the cranberry bog because there's nothing there to slow them down. And when those trees were removed to build 41 Pierceville Road, nothing against my neighbor, of course, we had 9 trees because there was nothing there to stop the wind drop in our yard, and 3 of them kind of piggybacked on each other and came within an inch or 2 inches of our back deck. So my concern is now we're going to be removing more trees, and what kind of backdrop are we going to have for the winds then as they barrel across the cranberry bog, and then we have less trees back there as a backstop? I don't want all those trees in my house.
Yeah,
So which property are you located at?
39, we are just...
The second one to the north.
This one
That
here.
one will, yeah.
We're right next to the cranberry bog.
Okay,
So the north wind comes across the cranberry bog, it beats on the trees that are right there that separate us from the cranberry bog. And like I said, that following winter, after they dropped all those trees for 41 Pierceville Road, which is on the other side of us, we had 9 trees drop in our yard just because of the winds.
so none of the trees will be cleared to the rear of your property. It's just gonna be, I guess would be to the west.
so Will, are you just clearing where the road is going in, and the lots themselves are staying wooded until a property owner decides what they're gonna do?
So I believe we left like 40 to 50 feet of backyards for each house, just for safety, for trees to be cleared, but, we did leave a buffer along that eastern property line, and then a portion against the pond there.
Because if you guys have ever been to a ball game, you notice that the weather's very turbulent there, the winds are very high there, and that's essentially what you have with the cranberry bog. And, my neighbor's house is to the west of our house, so the winds come across our property, and the tree buffer there before that property was built used to be thick and was able to stop that wind. But now we have less of that, and we have the trees getting beat up even more, and that raises even more concern. You're going to remove more trees.
Madam Chair, through you to Paul at Allen and Majors, just a question. And then I have a question for Josh. Paul, what kind, I'm not suggesting we would, but what kind of site plan remediation could we apply to do wind blockage? I'm not aware of what we could possibly do. And I'm aware that these trees are pine, low roots, and all the construction that's going on in Rochester, my daughter just built a house, they had 31 trees come down. But it's going to happen because of the nature of the trees and shallow roots. So I'm not ignoring it, but I'm just asking what can be done from a design perspective, if anything. I'm not suggesting we would impose it, but I don't even know what you could impose.
Yeah, I'm not sure what you could impose, other than creating a larger natural buffer. But again, once you start cutting down some trees, all the other trees are going to be susceptible to additional wind.
And because of the kinds of trees we're talking about out there, they're just,
Yeah.
okay. All right, so there's no standard design solution that you could say, oh, well, we could build a 75-foot concrete wall and no, I obviously I was exaggerating. So, Madam Chair, through you to Josh, while I'm aware in zoning bylaws there are protections for air rights and visibility, I'm not aware of any zoning ordinance, or not ordinance, certainly not in our bylaws, but in the Mass General Law that talks about wind implications for your neighbors from construction. I know we have stormwater, all kinds of stormwater management, but I'm not aware of wind management, a corresponding wind management requirement.
Yeah, I'm not aware of any either, and I would even go as far to say that there was another project in town where we tried to make the argument that a large amount of clearing would have a detrimental effect on the buffer zone to a wetland. And that was our argument, is that the effects of the clearing would create more wind, more turbulence that would bring down trees that would affect the wetlands, and the state disagreed with our stance on that. So if this went to the state level, there's almost no protection that they're willing to attribute to the Wetlands Protection Act on it either.
Yes, so my just so you understand, we very much have stormwater management laws, which you've heard us spend a lot of time on. Unfortunately, we don't have any levers for wind management in our zoning ordinances. So we can't legally impose a requirement. But under site plan review, we can do reasonable design accommodations, which is my question to the engineer, but it doesn't appear there are reasonable design accommodations that we can impose either. So I'm not sure what, I'll think on it, but I don't know what we can do.
Can you confirm which house is yours on
39?
that drawing?
Way up by the bog.
Where the cranberry bog is, we're to the left of the cranberry bog, where
So you're
that
right
immediate
there, right
house.
there.
Okay.
And 41 is right, is if you're standing on the street facing our house, 41 is to the left, and then 49 after where you're proposing the development, and then,
Yeah, I guess I'm looking at the north arrow, and if it's northerly winds, which are the winter winds,
yes, ma'am.
it looks like the clearing is actually to the west of you, so,
But when you remove the thickness of the trees, there's nothing there to stop the wind.
right, but if the wind is coming from the north, it's hitting you before, it would not,
I know, but with the convection of the wind and whatnot, when we had the bigger tree barrier before 41 Pierceville Road was built, no trees fell.
So which
The
one was
immediate
41?
winter after 41 Pierceville was cleared, we lost 9 trees. And we've continued to lose trees ever since.
Yeah, I think that she has a reasonable concern. I'm
yeah,
just not sure.
absolutely. I
Yeah,
just don't know
agreed.
if there's anything we can do, and I'm looking at it and wondering if this project is actually going to affect you, but maybe it is. I don't know. I was just looking at the
Well,
wind.
wind patterns are clearly going to change
Yeah.
whenever you cut trees
Yeah.
down.
Yeah.
When was 41 built?
About 7 or 8 years ago.
So 41 is the one
like
that's
it's
between
17.
you and the project, is that right?
If you look at the computer screen, Madam Chair, so this is 2016, this is 39, the
Okay.
Madam's house.
Yeah.
And then 41 here.
Wait, I
is
can't see your
constructed in
cursor.
17.
Okay, yeah.
Sorry, right above the vertical there, Carl.
Oh, okay, I'm
This is-
looking too
this
high
is-
up, yeah.
Yeah, this is the one that was constructed.
Yeah.
And
Again,
then
no
our-
disrespect to my neighbor, but ever since that house has been there, you know, trees have been falling, what appears to be sturdy trees. So that's my concern. If more trees are removed, are more trees going to fall? And am I going to end up with a tree in the middle of my house as a result? That's what I'm afraid of.
Yeah.
Well, it's conceivable. I'm not sure we can impose anything. Paul, what about like lines of arborvitae or things like that? Windbreaks, they don't,
No, I don't think that's
No.
going to protect pines from
Right.
falling. So.
Yeah, those winds are 60 feet in the air. You know, normally it's the wind catches the top vegetated part of the pine tree and they end up snapping.
yeah.
Yeah.
No,
Usually
I,
twist and a snap.
like I said, Corey had 31 trees came down this winter
Yeah.
It's tough.
for the exact same, right across from a cranberry bog, the trees all, and it's like a wind tunnel.
Yeah. Yeah.
But are we clearing any trees behind her property?
No, there will be no.
Her property is,
Where are the trees going to be cleared? What
So-
trees, along where the road is going to be put in, I'm assuming, right? And then the houses that are going to be built are going to be built kind of diagonally behind my house, a little bit across the pond, if you will, and behind those trees that are behind the left side of the pond, I guess you could, the back side of the pond, I guess you could say, right?
Yeah, so this dark squiggly looking line there, that's the proposed tree line.
So we're clearing nothing behind your house.
Correct.
But like I said, when 41 was built, we lost trees that first winter, and then we've continued to lose trees. We lost a tree to the point that it actually caught on fire as it hit the power line.
so Madam Chair, and I fully appreciate the applicants. One of the things that, when we do subdivision control, we don't get into the individual construction of the
Right.
individual
Right.
properties, so we can't regulate what happens on those properties.
We can hear your concerns, but
Yeah.
there's not a whole
Well,
lot.
and I'm exploring. I looked. I can't find any lever that we have to pull.
Well, I think 2018 was a really bad winter too.
Oh, yeah.
2018, we had a few nor'easters in March that were back to back to back. And that may have been part of the reason for it, but I remember 2018 was a pretty tough winter.
Yeah.
But as we cut that, which is the whole reason we talk about cluster,
Development.
Development.
it's not cluster, what do we call it? It's the aggregate impact of.
Oh, cumulative impact.
Cumulative, that's the word I couldn't reach for.
Cumulative impact, yeah.
And there are no cumulative impact laws on the books either. So these are things we struggle with and consider. We think about them, but we have few levers to pull
On private property.
on private property.
So our options to protect our home is to cut down all our trees on our property is pretty much what you're selling, or sell and go move someplace else? Is that pretty
Well,
much my
I'm
options?
not saying, what I can tell you, again, now, this is personal. My daughter has the exact same problem. They brought their insurance agent out. The insurance agent said, we've looked at this. We're not going to cover you anymore because of those trees. You need to take them down. So they had them all lumbered.
So we have to forsake the beauty of our property? I apologize, it is very
No,
personal
I'm,
for me.
I'm,
I have
I'm,
nothing
I'm only
against,
responding
know?
to you as a personal,
Yeah,
we explore what levers we can pull. We're bound by the law.
appreciate that.
And the person who owns this property has rights as well to develop his or her, I don't know if it's a his or a her or a company, but,
Yep.
and,
I
but
understand.
zoning is designed to try and balance these needs, and we try and balance them. Conservation, we all work together within the limits of, but the nature of this community is changing, as you can see. And we worry about that cumulative impact is one of the things we talk about, but there's going to be continued development in town. There's going to be fewer and fewer agricultural and wooded areas. The nature of the town is changing. And we're trying to navigate through that. We have to relook at the master plan coming up, but we're not going to be a rural agricultural community for the next 50 years. It will, fortunately, I probably won't be here in 50 years. I hope I could live that long, but it's hard. I would be 120 then, I probably.
You are not alone in feeling this way.
But I wanted the citizen to understand that we try and explore every lever we can, and we work with the developer has responded to comments, and we do what we can. So your concern is noted.
I don't think there's any legal standard the board could sit on that says they could deny or heavily modify this project based on the effects of the wind.
And not only that, there doesn't seem to be any simple solutions we could apply. Under site plan review, we have lots more kinds of latitude, but there's no obvious.
And I mean, I'm speaking just for my property, but there's 41 Pierceville Road, there's 49 Pierceville Road. All those properties are going to be impacted by the removal of these trees. And
Development,
forsake
Do
the
the
ones
best
that are
we
there
can
for the
minimize
new
the
and up
impact
and
of it.
coming is not fair. And I know your hands are tied, and I'm not upset with you. I understand what you're saying to me. I just wanted to get my objection noted as far as the tree removal is concerned for the properties that already exist there. My neighbors at 49 have been there for many, many years. We've been at our house since 2011, and it's been a beautiful property. But it seems like that landscape is changing from what you're saying.
yes. But, I'm sorry, I spoke extemporaneously, but
No,
from the
you're
heart,
fine.
but.
Yeah.
You're
Yeah.
fine.
It is.
It's-
And
it's
your point is well
difficult, but-
taken, that
Yeah.
this town is changing, yeah. We're seeing it in every project that's going before us, and the impacts it has. But, it is, property rights are protected as well, so we try to do as best we can.
Thank you.
Thank you.
So to answer your question, I know the HOA is something that we really feel strongly about. So that's one of the reasons, and I think we have someone else, to continue it.
I'm Joyce Christofalski, Krystoffolski, 49 Pierceville Road. I'm the lucky person right next to the end of the street, and I am very well aware that you can't do anything about the tree removal. I'm just wondering, who's going to own that piece that abuts my property so that when the trees from there, fall, I want to know who I'm going to get recoup my damages. And when my driveway is undermined from the, and what happens, I want to know what happens and who's responsible when this HOA doesn't maintain, just doesn't do what they're supposed to do, because I'm very well aware that the town has no oversight on it. You can issue as many letters as you want, and it doesn't matter. So I want to know what's going to happen.
Yeah,
Yeah, this is civil action.
certainly the HOA.
At a cost to me when it can be prevented now.
In terms of the maintenance of the stormwater, the performance bond is a mechanism for the town to say, hey, you need to do this required maintenance.
Oh, I'm
And
very familiar with it.
if you don't, the town will do the maintenance on our own, and then we'll draw from the performance bond to
That-
cover
that-
those costs.
That was just for stormwater. She was talking about all kinds of.
Right,
And well, snow removal, when they push it up against my property line, and that doesn't go down a storm drain, and it goes and undermines my 80-foot driveway, then what?
We can't.
Right, but this is my
Yeah,
thing,
we can't,
there's
yeah.
no, it's not a public road, so therefore it will not be maintained. You know, it's supposed to be. I work for a town, I'm very familiar with what happens. We have an HOA now who has a bridge that's failing, the storm drains are not taken care of, and there's no money to recoup because there's no money there.
Performance bond.
There's no
Right,
performance
so-
bond, right?
Yeah.
I actually don't know that there's no performance bond, but there's issues. Snow removal is a problem, so I'm just curious what's in this HOA to determine that there's going to be snow removal, that it's not going to be pushed onto my property, all of that stuff.
It's all,
That's what.
we're working on trying to
We're
get that
working
written
on, yeah.
out.
And the stormwater management has a maintenance plan, which again,
Has the
Concom
the
has a bond.
bond.
Yeah,
Yep.
I get
Yeah.
that piece of it.
yeah.
My concern is more when the HOA fails, and then you're left with properties that, you know, roads that are disintegrating and undermining the neighborhood in this, not in the property value, but in the, just the physical ability of the neighborhood to function because things aren't being taken
But
care
that
of.
would dramatically impact individual property values. If your road into the,
No, that's what I said. I'm not worried about property value. I'm worried about the fact
but
of,
that's why they would be motivated to maintain it.
That would, it would affect the neighborhood's
hope.
property values.
Because none of these roads will
But she's describing
be taken by
reality.
the town. The town has made it very clear, so that is why this is really important, that roads be maintained, stormwater management, the bond, all of that.
and I get that, and I know that you can only do what you can do. But my concern with this project is that's all well and good on paper until it falls apart and there is no mechanism to get any kind of relief if something goes wrong, when things don't go according to that document. Because there's no little pot of money that's starting this out.
There
Chuck-
is,
There is a little
Other
pot
than
of
the
money.
bond.
Josh, what's the scope of that performance bond? I mean, we could always add another performance bond.
270,000.
No, no, no,
270
what
for
is the
storm
scope
management.
of,
It's the maintenance of all the drainage
Right.
infrastructure on site.
Under the storm management report, there's a maintenance, operation and maintenance.
no, but we
plan.
could impose a performance bond if we
There's already
thought,
one
I
there.
mean, on other dimensions of the.
Problem is the town won't accept the street.
And I get that.
And it's a
What?
shame on the town.
But the town can't afford to maintain the street.
And I can show you sections of town where the road doesn't really exist.
But
In
I'm
HOA.
always saying that the town says they don't have the money to take on new streets, and we can't raise taxes.
So
Right.
our development, which raised for the town on an annual basis $300,000.
Let's,
I know.
we've
Yeah,
had
we're-
your
we're
HOA
digressing.
You're
discussion.
dealing with the reality, which is,
That they're
Roads are
not
not
going
gonna
to
be
accept the road.
taken.
That's the
yeah,
reality
public,
of it.
as public roads. right?
So we'll do what we can with the HOA. We've got the performance bond. We will consider
Right.
whether there
We
are-
understand, it is frustrating, because you are right, that HOAs can disappear, and then you really keep in mind that the owners are the members of the HOA.
Oh,
So,
I know.
you do have recourse, ultimately,
It's their property
yeah,
values.
against the
that-
homeowners that are part of the HOA.
Yeah, but you
So-
would have to, well, the HOA can't go away.
No.
So you could
No.
sue the HOA.
Well, the town ignores it. I mean,
No, but if she
Yeah,
goes to
I-
court and
yes.
sues the HOA, then
Yeah.
all
All the
homeowners are
homeowners are
party.
part
We have
of
a
it.
judgment.
Right, but the point is they shouldn't have to get to that point.
know.
This should be prevented by ensuring that it is strict and ensures that everything will be taken care of.
Yeah.
The
Because it's gonna wind
document,
up costing me money.
the document is we could write, but if nobody does it,
Yeah. It's a challenge. And I don't disagree that sometimes it works, and then every once in a while you have a group that just don't want to bother. But,
I have a whole neighborhood right now that the person that did it just didn't pave the road. The fire trucks can't go up it because the trucks will fall through.
Then the homeowners on that road
Yeah,
have a
it's-
problem.
Believe me, it's a whole thing.
Yeah.
And that's my concern, like, when stuff starts to disintegrate and falls by the wayside, it's not just that street that suffers, it's everybody around it. Okay.
Yeah,
No, I
no, I
appreciate
mean,
being
we're
heard.
hearing,
Yeah,
we're hearing
I-
you. I just,
I think the planning board is moving in the right direction by trying to establish a well-defined HOA document
Yeah.
before approving the project. And I think that's what you're looking for. I think the situation that you're aware of is, one, a failure of the developer to establish the road.
Well, I don't have much faith at this point in the developer, as in, we've been coming here for months now, and things haven't been done. So, sorry if I'm a little skeptical that they're gonna follow through.
The project hasn't been approved yet, so.
No, I understand that, but one would think if you're that hell-bent on getting a project approved, you would, I don't know, comply and perform and provide the information that's been requested.
I think our planning board has done a very good job of ensuring that the subdivisions they have approved have been built to a standard that is appropriate. For instance, for all the subdivisions that I'm aware of that you guys have approved, we have a set of inspections that are done while the roadway is being installed. And Allen and Majors goes out, the subgrade is placed, Allen and Majors will go out and do an inspection to make sure the depth was done. So while you have concerns about the developer's ability to do it, the planning board has established a list of conditions within its approval that ensures the developer does it.
Guess we'll see. Thank you.
Thank you.
thank you.
So,
So we are,
continue till,
So just in
Next
terms
meeting.
of conditions, we need to make sure all those road inspections,
mhm, mhm.
we have a
We have
template.
sort of we have
We have
the
the template.
yeah,
basis,
we do,
right,
yeah, for sure.
right. So we're continuing to the
Is there anyone else
23rd.
that
and
wanted
we-
to speak? Do we know? No? Okay, sorry. I didn't mean to interrupt you.
Continue to the 23rd. Yeah, I
Basically,
didn't see any other hands up.
Okay,
how much time does she need?
I
basically?
moved
Yeah.
it, oh, who?
I can get it done, assuming council's cooperative.
Well, it's really a conversation with council
Yeah.
for
And-
you,
And production of a revised.
by council, not by you.
Mm-mm,
Yeah,
mm-mm, Correct,
thank you.
If it's
Yes.
not available, we can continue it again.
we'll see.
Okay,
We're not going to approve it until we have a satisfactory document.
right.
I mean, we're not heading
So
toward
is
denial.
2
but-
weeks
Also,
gonna
I don't
be,
want to put her undue pressure.
right.
If she's gonna need,
No, that's okay.
It sounded like you
Yeah.
had sort of
I've
done your
already
review.
marked
and-
this up, and I have a list of,
okay.
so,
So, it's a call in the next couple
If
of
she's
days.
confident, then next meeting,
yeah, so we can
Get it to me and I'll get it to Will.
sounds
Do you
good.
think that that's enough time?
Yeah, I can't speak for
Okay.
council, but we'll
So
try
we
our
can-
best, and then if we have to
We
continue
need to
again.
continue
ready.
again.
Actually, do you know who your council is? Do you know who's, because I don't think we've seen council on this project.
I don't know the name.
Just wondering, okay.
So we'll continue to the 23rd, and
I move that we continue Pierceville Road to the meeting of the 23rd with the expectation that we have a revised HOA document.
Sam, what
second.
all right.
Does he agree?
He
The
did, I thought he
23rd,
nodded.
yeah,
Yes.
yeah, it sounded like you did agree.
Yes.
All in favor?
Please, aye.
Julie Moran, aye.
Carl Schultz, aye.
Sam Corbett, aye.
Jane Gleason, aye. So we'll see you on the 23rd.
All right, thank you all for your time.
Thank you.
Site plan review, special permit.
And you all have been very patient, thank you. Thank you. You've been patient.
Is this a new public hearing? or
This
can-
is a new public hearing, so I need to open the public hearing.
Hi, Rick, how you doing? Peter, how you doing?
Obviously difficult.
So we will open the public hearing. Notice of public hearing, the Wareham Planning Board will hold a public hearing on February 9, 2026 at 6 PM in room 520 of the Wareham Multi-Service Center, 48 Marion Road, Wareham, Massachusetts, 02571, to consider petition 26-2 for a site plan review / special permit from the requirements of Table 320, Article 5, Section 590, and Article 15 of the Wareham zoning bylaws to Frederick C. Mannix, trustee, care of Peter W. Titlebaum, Esquire of 30 Oak Street, Wareham, Mass. 02571, proposing parking in excess of 10 spaces associated with the construction of 2 commercial buildings with 8 and 7 bays respectively, located at 238 and 240 Sandwich Road, Wareham, Massachusetts. Assessors map 133, lots 1100A and 1101A in the CS zoning district. So,
I move that we open the public hearing.
Second.
all in favor?
Thank you, FT Stack.
Julie Marie and I.
Carl Schultz, aye.
Sam Corbett, aye.
Yeah, I'll pay.
And Jane Gleason, aye.
Sorry.
Thank you.
So, if you could state your names.
Yeah, I'm Peter Titlebaum, I'm the project attorney. To my right is Fred Mannix, he's the property owner, and to my left is Patrick Tropiano, he's the project manager.
And if you could raise your right hand and say, I swear to tell the truth, the whole truth, and nothing but the truth.
I do. So help me God.
Thank you. And I will turn the floor over to you.
Well, just as a brief project history here, back in 2022, Mr. Mannix went to the Zoning Board of Appeals and got approval to build a Level 2 care facility that was going to hold up to about 90 beds. Since that time, he's gotten both extensions from the Zoning Board of Appeals and, as you referenced in the earlier hearing, under COVID relief acts, so he still has the benefit of that permit on this property. However, as you, I think, were all here at the time, a little over a year ago, we came before you and discussed generally, it wasn't an application, it was just to get feedback from the board, a proposal to put up 2 buildings with 8 and 7 bays respectively for commercial uses. And at that time, the board gave us some helpful feedback and some helpful thinking. We did apply for a building permit and were denied by the building commissioner on the basis that there was going to be some level of a storage associated with the uses we contemplated people renting these bays out for. And you've got the denial letter in your package. So subsequently, we went to the Zoning Board of Appeals this past October, and we got special permits and variances that effectively allow us to add the storage use to the range of uses that you can have as of right in the strip commercial district. The concept that Mr. Mannix has embraced now is to have effectively business incubator units. There's a need in town for contractors, small retail, and things like that to have small spaces where they can operate out of. Currently, if you have contractors, we've got plumbing contractors, we've got electrical contractors, all sorts of people are parking their vehicles in yards. And I think it's to the advantage of the town to get some of these things out of the neighborhoods so that you don't have to look at a dump truck every single night when you come home for work. And I think it's to the advantage of the business owner who has the dump truck so that he has his vehicle kept in a commercial setting. And what we did also with the Zoning Board of Appeals, because the building commissioner, in addition to uses, he was concerned about the number of parking spaces. His calculations showed a set of numbers, I think it was 24 and 23. No, we said 27 and 24, but he had limited us to somewhat less than that, so we obtained a special permit in regards to the enhanced parking spaces that we were looking for. And we're here before you because we're in excess of 10 parking spaces, which triggers the section of the bylaw that you read into the record requiring planning board site plan review. So that's why we're here for a second permit, if you will.
Madam Chair, through you to the town planner, which version of the bylaws are we using to consider this application?
This would be not the updated contractor base. If that's the question you're asking.
No, which
No.
version of the zoning bylaws?
They're our most up to date.
Oh,
So the October,
24,
23.
23?
23?
23.
no, we had bylaws passed at town meeting.
Right, not those, because those have
They
yet to be
haven't-
approved by the Attorney General.
You and I still have a debate about that. Okay, you want us to review these under,
Current.
So is the
Our amended contractor bay, which was approved at the town meeting, is, in my opinion, not in effect.
okay, so it's October of 2023.
Correct.
That's the
Yeah.
version of the zoning bylaws.
So if it gets passed by the, or approved by the AG,
We still have to update the zoning bylaw and then we have to advertise that the zoning bylaw is updated, and we have to post it in a number of places.
so what would be the applicability date of that bylaw? What would
I
be the
argue that it
threshold?
happens the day after town meeting, and it's supposed to be posted by the clerk on that date, but this has been an
Yeah.
ongoing.
But the AG always does his review, so
Wait,
so,
It doesn't matter. If you read the state bylaw, it goes into effect at town. This has been my argument. I've never-
Mr. Schultz's stance is that if it gets approved at town meeting, the town then has the ability to advertise that it was approved, and it should be in effect that day that it's advertised.
And then-
My argument is that we are not going to post an approval until the AG gives us the approval, which generally happens somewhere 90 days after we submit a Form 7 to the Attorney
So
General.
for this.
so then does it still go into effect the day after town meeting out?
No, it doesn't go in effect till it gets posted.
Right.
So I argue the town is delaying,
It doesn't retroactively go into effect?
no, but it could go in effect that day if we posted it. It's been an ongoing point of debate, or not debate, but
It's-
discussion. It's a procedural,
Right.
Okay.
And I think maybe just recognizing that these things have a fee associated with them, that's probably why there's a delay from the clerk's office to post it after town meeting and then have to repost it again after the AG's approval. It's, one posting is probably what their goal is.
Yeah. So the new contractor bays, this didn't fall under, and was that part of the use variance?
We did not specify contractor bays specifically or in particular, but the storage was really the issue for the building commissioner. It's certainly understood that that without the storage use, you really couldn't have a contractor bay. So it was kind of a circular sort of thing here.
Yeah.
So what we effectively did was legitimize all the aspects of the uses that would go into a contractor bay. So we have that approval from the ZBA. That's
We have
clear
a-
in their decision, and that's clear.
we have a copy of that decision in
Yes,
here.
yes, we did provide that. So it's clear that a contractor bay eventuating from what we do, which is what's going to happen here, because we're not necessarily limiting ourselves to contractor bays.
Right.
Because, again, we got permission from the ZBA for all uses under the bylaw in conjunction with storage associated with many of those uses. So it's kind of interesting. In terms of a business incubator, it's not something that you can, put it up and know ahead of time exactly what you're going to get.
Right, you're gonna be somewhat beholden to who comes across your threshold.
Yeah, I mean, the assumption by Mr. Mannix here is if he builds it, they will come.
Yeah.
But who they is can be a mix.
Yeah.
If I may, Madam Chair, and the board, the idea here was to have multi-uses because of the size of everything. And storage came up because any use that allowed inventory, like if it's a shoe store, and you have shoes more than 100 feet or something like that, they considered it storage. So that's why we had to go to the board to establish that the uses that are allowed in CS can have storage use with them. Now, they're not necessarily contractor-based. These, because of the location, it could be a medical rental place, we're near Toby Hospital. So something like that could be, in conjunction with what's needed in the neighborhood.
Yeah.
So the board, as we explained, Peter explained to me, has given us the ability to use multiple uses in that setting. Anything is allowed in CS, nothing beyond that.
And they told us too, that if there were some use came up that wasn't allowed in CS, we'd have to go back to them for another variance,
Yeah,
so.
sure.
So there are some limiting factors here. But, I mean, to me, a helpful exercise for the board might be, and I actually recently did this for another client, is print up the use tables, take your yellow take your yellow highlighter, because the headings only appear at the top of the thing, and you're flipping through 10 pages, and just run it down there, and then you see the whole sort of panoply of uses that you can do in the commercial strip. It is the most, I would say, the commercial strip is the most wide-open zoning in town, for a reason, because they wanted to put businesses out there, and it covers pretty much any kind of business.
Yeah. Questions from the board?
Could a person rent two?
Pardon?
Could a person rent two? Take them off?
Oh, yeah, yes.
Could you put a door in between?
Yeah, we anticipate smaller people, because it's like a carton of eggs. You can mix them all up. I mean, I don't think anybody would rent the building. It's not set up that way. And it's not that much of an area. It's a great spot for the people who want to use it. You're next to 25, you're right on 28. It's a state highway.
And it sounds like that much of the use would be during business hours, looking at, much of the use would be during business hours? Is that
Oh,
kind of your
yes.
thought?
Yeah, this is strictly, I think there's something in the bylaws about that, but
Right,
this would be.
exactly.
Yeah.
Okay.
Can you tell me, there are 1, 2, 3, 4 existing buildings. What are their uses? Are they residential, commercial?
There was one building, I think some of that, Madam Chair, is existing foundations. There's no buildings there. There used to be a farm. There was some outbuildings.
It's Tootsie Farm.
So this is the,
Madam Chair, you're looking at different properties.
Yeah, the one to the right is
that's
the real
Upper
estate
Cape.
office.
That's Upper
Upper
Cape.
Cape
That's
Realty,
Upper Cape.
yes.
Yeah, and is there a residence on the upper floor of that?
No,
Or is that just,
I don't think so.
no.
There was. Oh, wait a
There's
minute.
no one living in there, I can tell you that, because I plowed it the other day,
Their
so.
property had a problem with, I think Mr. Angus was encroaching on Mr. Mannix's property at one point.
Yeah,
Well, that was it. They tried to.
that's a long story.
That's a long story.
That's a old wound.
Well, that's not a wound anymore. We won the case. They tried to do something. But I guess we've come full circle, Mr. Baptiste.
The fire department has looked it over, I just want everybody to know, and they made two changes. They went to Cape Cod berms instead of curbs because of the way the truck would have to go around, and the outriggers for the big truck, whatever. And they made us change, we had a 20-foot radius on the turn going out the back, and they required a 25. So those two updates have been done, and the plan is available, and I'll get you copies of it.
Yeah, that'd be great. So you have a letter from them, or they?
No, they don't issue letters anymore, apparently. I asked about that, and they said, we don't issue letters. Chris Smith.
Fire department?
Yeah. Chris Smith used to issue a letter,
Yes.
but the
I've
new guy
had
doesn't
letters.
issue letters, so.
Onset
you-
Fire?
Yeah, no, this is Wareham. So you'd probably have to call them and ask them.
Yeah, I don't know. They most certainly issue letters on other projects.
We haven't gotten one in a
I-
while, Judge.
Chris Smith has been gone? Because I talked to him the other day, just prior to this on last Thursday, I think it was. Might have been last Wednesday. And because he had asked us for a couple changes, which we did. you know, right away for him, so he could have whatever he needed. And he said to me, he said, I said, you're gonna give me a letter or
Was
whatever?
it Captain Crab?
Yeah, it was Captain Crab.
He'll supply us a letter. When I
You
prompt
asked
him
him?
to do so, he will.
Yeah, so,
So if you ask him, then he will, but he wouldn't supply me with a letter.
Well, I'm glad we have a Captain
Yeah.
Crab Whisperer here, because
Yeah, yeah.
that seems to be the key to the.
I just wanted you to be
Doorway
aware,
here.
because he wouldn't give me the letter, so I wanted everybody to understand what happened.
I would get an answer from Captain
Yeah.
Crab.
I would appreciate that, because that's, that'd be good.
important to us, yeah.
Yep.
Yeah, your eventual insurer would like to see that, too.
Well, everybody
Yeah.
would, you know.
Yes. Sure.
I think we sent the update, right? We put the update. The update is up, right? We sent it to .gov there,
Let me see.
yeah, it should be up there.
Should be up there. Nothing, excuse me.
It's not all
It's
over.
just two changes.
Back in August, or?
No, this was just recently.
I don't see a plan.
This was, he approved it only
doesn't
only
have
told
all
me
the
about it last week. But we
requirements
did
for-
the plan about 3-4 weeks ago, so.
Would you have submitted the most up-to-date one, Peter?
I think so.
I would think so, but I'll certainly check and make sure
And
that
make sure
that's
it gets
but
up
if
there
not,
for
I'll
you.
So you
take care
said
of it.
that the radius on
Going out on
They just
Plymouth,
ignore the
Plymouth is
whole rules and
25?
yeah,
regulations.
it's 20, he wants the radius 25, so that's what we did, 25.
I'll check.
We have plenty of room
You
to
don't
do
see
it.
it, then I'll get it right up.
It's
Yeah.
just that that's
Do
the
we have a site
requirement
plan?
that they wanted.
Site plan? Are we gonna have a site plan? Besides,
Okay,
I
so
see a
Josh,
application.
this is not a complete application in front of us, so.
I don't see a plan.
The plans are there, you have plans.
Do we, okay, so maybe we don't
This,
have.
this,
No, that's just, there's some plans somewhere.
Okay,
I printed one out.
It may have been a failure on my part to throw it on in the box.
okay.
I'm sure you gave us a plan, so.
we have,
Yeah,
we
there's one
have
for each
the,
of you and a big set of
folder.
plans
That's what I
and the whole
saw.
thing.
Jane, is the folder that, in there with all the green cards and,
The folder should be in there. I'm thinking it was a failure on my part to put the plan set into the,
Yeah, they're
And
Make these
53G?
drawings,
oh yeah.
Yeah, a set of plans would be helpful, probably.
Yeah.
drainage counts.
Kind of hard to look at
Yeah,
some
that
words
was
on
a-
a piece of paper.
Okay,
If
that's
the
fine.
board would afford me
Yes.
7 minutes, I'll go grab them.
no, I don't
the
think,
office.
if he can
We'll
go over
grab
them
them.
on the screen. I'll download them.
Okay. They are uploaded, I can assure you that. I think it was,
Yeah,
sorry, it was my
that's
first
how I
time
got
putting the box
this.
together.
Did you hold a preliminary design review according to the?
Yeah, the applicant came in, we did discuss it, and actually at that time when we discussed it, we were first drafting the contractor bay language, and I think your project actually met 90, if not all of it, at that time. So there was a discussion had, we did talk about the project.
Yeah, the other thing is that they are going to be sprinkled by their size, okay? That they have to be sprinkled, and there will be interior parking as well, so there'll be, you can pull your truck inside, but those are not counted in the parking
No,
numbers.
they don't, yeah.
Okay.
They're not counted.
Similar to another project we saw a while ago.
So, we should have Alan Major do
53G?
a review.
Did, Alan, you guys did one for the ZBA, right?
No, we did not.
Oh, you did not,
No, that
okay.
was just a use. It was just a hearing on the use.
There was a special permit.
Yeah, there was a special permit for parking.
No, not for parking site plan review. Well, you got the variance, but,
We have to satisfy two jurisdictions.
yeah, no, I understand, but there
no.
was a special permit, so I'm
Yeah,
surprised there
so-
wasn't a
So we'll need,
No,
a
peer review.
No, the zoning board routinely approves special permits without review by Allen and Majors. I
Okay.
think the majority is site plan, sorry. The zoning board of appeals will routinely permit special permits without review of Allen and Majors. I think almost every site plan review that comes before the town gets reviewed by Allen and Majors.
So we would be looking for their feedback.
Yep.
so we have peer review. Plans.
And we have submitted the stormwater plans.
Yeah,
Yeah, the
Yeah.
stormwater report was there, yeah, so
I think all
I'm
the
assuming that's
calculations are
online.
in there, too.
I'm assuming that's online.
Landscape plan, everything should be there.
Okay.
Yep.
So I think it's, yeah, it's turning it over.
Yeah,
Lighting, landscape, the whole 9 yards.
yep, I think it's a matter of us getting that review back from these guys
And then an opportunity, because I didn't look at
at the,
the diagram or
Drawings,
the
yeah.
plan.
Yeah, okay.
I don't have any further questions. I don't see anybody in the audience. John, is there anybody out in the ether?
This is going to be the quietest project you ever saw.
It took a while.
Well, you've been here, what, 3 or 4 times talking about various,
Yeah, we talked to you, yeah.
We've come back to what we started.
We've
back
done
in
our homework
2020.
for you.
The original plans, you look at the original date, it's been a while.
In fact, one of the only questions you actually had was Jane was concerned about the elevation. But now you have an elevation plan, so you'll see that it's not really as stepped as it appears to be.
yeah.
It's fairly,
If you look at it, you can see it's pretty flat. A little bit of hill, but not too
Yeah.
much.
and who's directly across the street? Nassarella's, or this is up?
No.
from-
No, that's the,
This is down way out
the
by
nursery
Lakeside.
school,
Yeah.
is right across the street.
Oh, the
Yeah.
nursery school.
Yeah.
The Upper Cape building.
I don't have any more questions right now.
Yeah, I don't think I have more questions right now.
I move that we continue till.
It's looking like the 23rd is,
How
and that's
long
way
does
too close.
Allen and Majors need,
Yeah,
well, we've got to get the 53G
Yeah,
funded. and
more
then
than 2 weeks.
yeah, yeah, so
Go to the first week in March.
March 9th or March 23rd.
March 9th, if it's available, yes.
Yeah, March 9th would be great.
we have the account.
I move that we continue whatever Jane read into the record to March 9th.
All in favor?
Mike Baptiste, aye.
Julie Marie and I.
Cross-Schultz, aye.
Sam Corbett, aye.
And Jane Gleason, aye.
Well, that was easy. Thank you so much.
Peter,
Continue, what happened?
I didn't expect them to argue over it.
Are you telling us that we have a reputation?
Oh, no, absolutely not.
This is going to go out on a state highway, right? So you've got to get over the DOT.
no,
It's, no, it's on Cranberry High, it's on
Oh, it's not.
Sandwich Road.
right, sandwich.
Oh,
is
that's
limit.
So that's not, Route 6 doesn't go
It's
that
where
way?
that old, the
No, I
gold-colored
know
house
right,
that's
I
been
know right where it
condemned
was,
is.
but I thought Route 6 technically,
Oh, it goes by, but our access is off of Plymouth
So much I've been paying attention,
need
but it was a really handsome house.
Oh, yeah. It's on Sandwich Road. Yeah. No, it's
so
right.
isn't Sandwich Road Route 6?
You're not doing a new curb cut, are you?
Beautifully
The state's gonna give us a curb cut in the middle.
Yeah.
Yeah,
It's one entrance.
too bad.
That's why I said,
Wide
okay,
entrance
so
in,
that-
you'll see it on
So
the
you will need a
plan.
curb cut.
And then
Got
there's
it.
an exit out the
that's
other
why I
side.
said you're going to
No,
go to
you're
the
right, right.
DOT and get all
You're
those.
100% right.
Yeah.
We have 4 curb cuts now, we're gonna consolidate to 1.
Yeah. Yeah, and actually, there's one right where we're going in, so it shouldn't be that hard of a.
We're done.
We're done.
Good.
Motion to adjourn?
Get out.
Thank you.
Still early.
Get out.
Get out of here.
Motion to adjourn?
Second, or I move that we adjourn at
Second.
8:28.
All in favor?
Baptiste, aye.
Julie Marie and I.
You have an account established already?
Carl?
Oh, aye.
We'll just have to check the balance.
Jane Gleason, aye. Good night.
Aye, 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 sir.